Okay, with that, I'll go ahead and call to order the State of Nevada Public Records Task Force meeting for August 5th, 2026. We'll go ahead and proceed with roll call. So I'll just call off the names. Please indicate if you're here or not. Ben Lippman.
Yes, I'm here.
Thank you. Brittany Walker.
Here.
Colleen McCarty.
Here.
Kaylee Work.
Here.
Leslie Nino Piro.
Here.
Mitch Fox.
Here.
Matt Morris.
Here.
Matt Christian.
Here.
Stacy Lindberg.
Here.
Okay, and Josh Hicks, I'm here as well, so we have a full house. Thank you. We'll go ahead and move on to public comment. We'll take public comment starting in Carson City, then we'll move to Vegas, and then we'll move to online and the phone. I'll note that we have received written public comment that has been disseminated to all the members of the task force. If you are making public comment, please limit your speaking period to 3 minutes so we can be efficient with our work today. With that, we'll go ahead and start in Carson City. Is there any public comment in Carson City? Seeing none, if there's any public comment in Las Vegas, please come forward to the podium. I don't see any. Thank you. We'll go ahead and move to online. Please indicate if you'd like to speak.
If you'd like to participate in public comment, please press *9 or raise hand in the Zoom window to take your place in the queue. Amanda Lyons, you are unmuted and you may begin.
Perfect. Thank you so much. Hello, my name is Amanda Lyons for the record, and I'm 15 years old. And I went through the current Nevada Public Records Statute, Chapter 237, to see if I could find loopholes and vague and ambiguous sections that I believe could be exploited. I bet you are probably thinking, what on earth makes this 15-year-old interested in Nevada public record law? Simple. I am interested in how different governmental bodies function through the law, and after attending the June task force meeting, I thought that it would be fun to read through the statute because I like finding potential and exploitable inconsistencies or loopholes since I've done mock trial over the past 2 years. I've come here today to share just a couple of the loopholes that I believe I have found. The first area that I have found was a little bit of vague wording under NRS 239.0107, Section 1. Not later than the end of the 5th business day after the date on which the person who has legal custody or control of a public book or record of a governmental entity receives a written or oral request from a person to inspect, and so on. The issue that I have found with this is that it appears that a government could not forward the request to the person with legal custody over the document and claim that the 5 business day clock, has not started. The next vague area that I found can be found in NRS 239.0107, Section 1, Subsection 1. Provide to the person in writing notice of the fact that it is unable to make the public book or record available by the date. I believe that the wording is very vague and it can be up to interpretation because unable is a high standard, but what unable exactly means is not defined. And the final loophole that I will share today can be found under NRS 239.011, Section 1. If a request for inspection, copying, or copies of a public book or record open to inspection and copying is denied or unreasonably delayed, or if a person who requests a copy of a book, and so on. The issue that I believe I have found with this is unreasonably delayed is extremely vague. How much? A month? 2 months? A week? It's not clearly stated here. To summarize, these are some examples of issues with clarity, precision, and clear standards that I believe could be needed to help fix the statute. Thank you.
Thank you for your comment and your interest in this issue. We appreciate it. Next commenter.
If you have recently joined the call and would like to participate in public comment, please press star 9 or raise hand in the Zoom window to take your place in the queue. Kathleen Light, you are unmuted and you may begin.
Hello, my name is Kathleen Light. I reside in Henderson, Nevada, and I want to again talk a little bit about my public records journey. The only public record I have received regarding my sexual assault complaint from the Attorney General came in May of this year. After waiting more than a year, it arrived shortly before I began speaking before this task force. That record consisted of a single page. It had nothing to do with my allegations against the former Deputy Insurance Commissioner. Instead, it contained an unsubstantiated accusation about me. It alleged, without supporting evidence, that I had been contacting my rapist daughter from multiple phone numbers and harassing her. There were no screenshots, no phone records, no call logs, and no corroborating evidence. Just an email from someone with no involvement in my sexual assault complaint. While I waited more than a year for records that should have shed light on my complaint, I was trying to alert the public to a much larger issue. A senior state official accused of sexual assault had been fired and later moved into another position of authority in a different state. At the same time, all of the deputy commissioners and the commissioner of the Nevada Division of Insurance quietly slipped away. Meanwhile, Northern Nevada homeowners struggled to obtain and keep wildfire insurance as coverage shrank and premiums increased, while Southern Nevada drivers faced significant automobile insurance rate hikes, and health insurance premiums also rose across the board for all Nevadans. These were not private matters. They involved the leadership of the agency responsible for regulating the industry and that affect every single Nevadan. Instead of producing records that would have helped the public understand how my complaint was handled or why so many senior officials departed, the only document I received after more than a year was a single page attempting to discredit me. It did not answer my request. It did not inform the public. It sent a message: stop asking questions. Public records law exists because government should answer to the people, not the other way around. But when records are delayed for more than a year and the only document produced attacks the requester instead of answering the question, transparency becomes an illusion. The public cannot hold the government accountable if the government controls what the public is allowed to see. That is not open government. That is information management. George Orwell warned that those who control the present can shape the past, and those who shape the past can influence the future. Public records law exists to prevent exactly that. Today, it is my request. Tomorrow, it'll be someone else's. If the law does not protect the public when it is most inconvenient for the government, then it is not protecting the public at all. Thank you.
Thank you. Next public comment from online or the phone.
If you have recently joined the call and would like to participate in public comment, please press star 9 or raise hand in the Zoom window to take your place in the queue. Kevin, you are unmuted and you may begin.
Thank you. My name is Kevin Lyons. I participated in the public meeting task force back in 2018. And came across this task force, thought I'd be able to offer some help. So will certainly make my assistance available. Trained in jurisprudence, law, and economics organization at Berkeley at Bolt Law School and business and public policy program. My specialty is mechanism design and figuring out ways to fix loopholes in laws. My daughter actually got interested in this earlier. I didn't help her or anything, but she spoke briefly on some of the things she was able to find as a high schooler. What I'm going to share today is just a couple of thoughts from surveying different public records law across the country. Have a company work with about 100 plus local governments right now. And the main big fix I wanted to bring to your attention. I know you guys have talked about a lot of good ideas, including the quick forum, ombudsman type service, is having a two-step process where, especially with technology now for search, what happens in a lot of cases is there'll just be a response back and it's not clear a search has even happened. And so what I'd like to suggest is kind of the main thing to think about, and I can send more information later, even answer questions if you'd like in a future conversation. Having a 5-day requirement to complete the search is kind of a best practice out there, including an attestation to what search was done. So the person knows what was searched. They can verify that that was the search they intended. They could narrow the search, which has come up, of course. That's a really important thing for the government side. And then from that, there's a clear list of items that maybe need to be reviewed or redacted and so on, but the other ones could be released quickly. And so from a mechanism design perspective, the idea is to have that search happen, have the search results be provided, and also create a little bit of an incentive where if you don't have those results provided, that potentially confidentiality is waived, or the ability to not provide those, to delay those is waived. So I'll leave you with that as a big thought, big picture, and appreciate what you guys are doing to improve the public records law. They definitely need a lot of work, and you're getting a lot of good advice. Thank you.
Thank you. Any other comments online or on the phone?
If you've recently joined and would like to provide public comment, please press *9 or raise your hand in your Zoom window to join the queue. Chair, we have no additional public comment at this time.
Thank you. We do have some additional requests up in Carson City, so we've got someone at the podium. Please state and spell your name for the record and limit your comment to 3 minutes, please. Go ahead.
My name is William John Connors, and I'd like to talk about my husband is in Ely State Prison, and the food there is atrocious, and I would like the legislature to do something about that because I'm very worried about him. He's getting sick over the food, and I know they just sent a whole bunch of people up there, and it seems like they're not handling it well. Also, my husband is there. He's been there for 8 months. He was transferred from High Desert Prison, and he hasn't been able to get out of his cell, or when they do let him out of the cell, he's not able to get outside to get some fresh air or even some sunlight. And I know they have a restriction, or they have a problem with not enough people to take care of the place, and they're probably working on it. I already talked to the warden, and I talked to the caseworkers there, and they said they're working on it, but it seems like they're working on it pretty slow. The last time I was at the legislature, which was a couple of weeks ago, the director actually stated that he had a drug problem in the system, and that confused me because I was under the impression that he was in charge of the system, and for someone like him to say that he has a drug problem, I mean, I work in the private sector, and if I went to my boss and said, gee, I can't control the situation, he would end up firing me, and that's why I was confused. Maybe he was asking the legislature for help in the situation, but it seemed like he was complaining, and he's a director. I'm under the impression that he's running the situation. And he's been there a while. I mean, you know, at least 4 years now. And if he has a drug problem, then, you know, he looks like he's not doing his job, and I'm really confused about that. So I was looking for some help here in the legislature. Maybe they can give me an idea of what's going on. No comments? No. All right. Thank you very much for the time to state my situation. I hope you guys can work on it and see if you can't make things a little better for him up there. I'm also speaking for him, but I'm also speaking for other people that don't have a voice, and I'm here for them too. Drug problem is a problem in the system. It's making people sick that are not using the drugs, and I don't want my husband going through any due hardship while he's in prison. The idea I thought was that you go to prison, that was the punishment. I don't expect to be punished later after I'm in prison by the prison system. Now, I was a prisoner of NNCC, and
So you're over 3 minutes, so we thank
all right.
we
Thank you very much for your time.
Thank
and,
you.
Good day.
Just so you know, we are none of us on this task force are legislators.
Not a
So
problem.
thank you for your time. If
All
you
right,
could go
thank
ahead
you.
and turn that mic off on your way out, I appreciate it.
Thank you.
Is there any other public comment in Carson City? We've got one more. Please state and spell your name and then go ahead and proceed.
I just wanted to make a comment about that if I could leave off a written comment with you, is that okay? Okay. I've had extensive experience with the Public Records Act, and I have to say that there's certain sectors of the government that are less responsive than others. Some are very responsive and helpful in guiding. The AG's office is one of them. They respond immediately, and if they don't have it, they'll tell me exactly where to go. Other agencies, such as the District Attorney's Office, don't even seem to have a website where you can make an inquiry. So that affects the local areas, because that's where we interfaces your constituents, is at the local level. We have, except for like welfare issues, we have little contact with the state. So it seems to me like the local area public records request system is a little less responsive. And some seem to be operating without even regulatory processes. The District Attorney's Office is one of them. I'm here also to really support the idea of mediation prior to going to court. I've been to court on issues. I have a third-party neutral training through the Bar Association in San Francisco. And I know the courts themselves don't like to, number one, have a record coming in that isn't full. So the mediation process would fulfill the record completely so that he's not being presented to issues he has no idea. In other words, there's no records keeping, he doesn't get a case, he gets some allegations and stuff. It's hard for the judge. And so the judge and the judiciary also has a concern about, their dockets and scarce resources. So the mediation process would be very helpful, even at a rudimentary level of resolving issues that don't need to go to court, right? So, and that's all my comment is. I'm wondering where I could leave off. Do you have a secretary? Okay. Thank you.
Thank you for your comments. Appreciate it. That will go ahead and conclude our public comment section. We'll move on to item 3 on the agenda. This is approval of the agenda. I'll note for the task force that I did have a request that we postpone items 9 and 10 to a future agenda. So those we will not be hearing those today. Does anyone else have anything else, other comments to the agenda? If not, I'd be looking for a motion in a second.
Mr. Chair, this is Matt Christian. As everyone here in Las Vegas probably knows, there was a Metro officer killed in the line of duty yesterday afternoon. And my understanding is that our presenter for item number 5 may not be able to be here because of that. I don't see him here in the audience, but I'm not sure if he's on Zoom.
Okay, thank you. Should we, my thought is maybe we go ahead and approve the agenda and we can just push that item to later if he's not available. And if he can't make it today, we'll just put it on a future agenda.
That sounds good.
Okay, any other comments on the agenda? If not, I'd be looking for a motion to approve in a second.
Colleen McCarty for the record. I motion to approve the agenda.
Second.
Second.
I had the motion from Colleen McCarty and a second from Kaylee Work. All in favor, please say aye.
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 Any opposed?
Aye.
Motion passes unanimously. Thank you. Yep.
I apologize, Chair. This is a quick comment. Leslie Nino Piero for the record. I believe Sarah Bradley, who is listed at number 7 on the agenda, is not going to be able to make it today. We did not receive word back from her. So I don't know that that agenda item will move forward. It's certainly not today.
Kaylee Work for the record. I do believe Sarah's been able to join us by phone, and she plans on speaking. Sarah, just confirming we do have you on the line.
Yes, we do have Sarah on the line.
Terrific. Thank you.
Excellent. My apologies.
Mr. Chair, Mitch Fox for the record. One more time, can you clarify which agenda items have been deleted?
We are rolling items number 9 and 10 to a future meeting.
Thank you.
Okay, we'll move on to approval. Item number 4, approval of the July 22nd, 2026 meeting minutes. Those have been distributed to task force members. Does anybody have any comments or edits or revisions to those minutes? And if not, I'd be looking for a motion in a second.
This is Matt Christian. I move to approve.
Thank you. Do we have a second?
This is Ben. I'll second.
Thank you. We have a motion and a second. All in favor, please say aye.
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 Any opposed? Motion passes unanimously. Thank you. We'll move on now. Well, we are moving to item number 5, which is a presentation from the Las Vegas Police Protective Association. Mr. Christian, I believe you said Mr. Abel is not there. I just wanted to confirm before we moved past that item.
Yes, thank you. He is not present live.
Okay, well, we'll just go ahead and skip that one for now. We'll come back to it later on in the agenda. We'll move instead to agenda item 6. This is a presentation from the Reporters Committee for Freedom of the Press. I believe Ms. Singh is online, and Ms. Singh, when you are ready, go ahead and begin your presentation.
Thank you very much. I'm just going to go ahead and share my screen. And I believe that you can see the screen, but please feel free to holler if that's not the case. Good morning, everybody. My name is Gunita Singh, and I'm a staff attorney at the Reporters Committee, where I've been litigating news gathering and freedom of information cases since 2019. I'm proud to say that Reporters Committee is the leading pro bono legal services organization for journalists in the United States. We provide legal representation and other legal resources at no cost to protect First Amendment freedoms. Today, Reporters Committee urges Nevada to reaffirm its commitment to government transparency and accountability. I understand that the task force is interested in determining how Nevada's Public Records Act can be improved. The best public records laws are those that contain strong provisions for transparency, are clear about what information is permitted to be exempt from disclosure, and afford an opportunity for administrative review of an adverse determination. Nevada already bears some of these hallmarks of a strong law, and I appreciate the opportunity to suggest where it can even better serve the twin goals of transparency and accountability. Thanks to the transparency offered by Nevada's Public Records Act, local news outlets have been able to accomplish incredible reporting. For instance, the Review Journal was able to get records from the Clark County Coroner's Office for autopsy reports of juveniles who died under the county's child welfare supervision to examine whether Child Protective Services could have prevented the deaths. The late Jeff German reported on data acquired from fire records and determined that the Alpine Motel apartments had not been inspected by officials for months leading up to the fire, despite a decade of failed inspections. The reporting prompted code enforcement reforms. The Reno Gazette-Journal noted the importance of public employees' retirement system data when investigating double-dipping practices by public employees. Then the strengths of the Nevada Public Records Act permit such important reporting about matters of public concern. And this task force has the unique opportunity to recommend changes to the Public Records Act that will bolster trust in government, save resources, and bring Nevada into conformity with best practices for transparency and oversight. First, we wish to address the possibility of an empowered and independent public records ombudsperson or access counselor. About half the states, DC, and the federal government have created appeals processes for requesters to try and settle public records disputes, so that litigation is not the only option. These measures vary in their investigatory and enforcement powers, political independence, and the deference a reviewing court will grant prior findings, but they all represent steps toward effective access to government information. The most effective ombuds offices are independent, that is, free from external influence, impartial, serving as a resource for parties who seek assistance, and empowered. One example is Connecticut's Freedom of Information Commission, which was one of the first administrative open records agencies and has long been heralded as exemplary. Upon notification from a requester, the commission can review the request, subpoena witnesses, examine relevant documents, and hold hearings. The member of the commission who hears a dispute issues an opinion that is binding, but is subject to review by the full commission or even in state court. In states like New York and Hawaii, the ombudsperson has explicit authority to investigate agency policies concerning access to public records and can recommend improvements. In addition, an ombudsperson is well situated to provide training on the public records law. Because of the discretionary nature of Nevada's catch-all exemption, where agencies bear the burden to prove the interest in non-disclosure clearly outweighs the public's right of access, instituting a check on the agency's discretion by way of a neutral and credible ombudsperson could be particularly beneficial in Nevada. Researchers have emphasized the importance of the ombuds office being both independent and impartial. For example, in neighboring Arizona, the public records ombudsperson sits in the legislative branch, where Patrick Shanahan, who long served as the Arizona ombudsman, quote, felt no pressure to cater to any political subdivisions due to the structure of the office, which by law makes it difficult for him to be influenced, unquote. In Virginia, the Freedom of Information Act Council established itself as the authoritative voice on open government, and those who come to it appear to be largely satisfied with its decisions. Some public records matters still end up in litigation, but these are typically cases focused on narrow legal issues that require more formal judicial interpretation. The consensus is clear among practitioners and experts that implementation of such processes can positively change agency culture by preventing non-disclosure based on animus or misunderstanding, as an ombudsperson is accountable to the public, the courts, and often other officials. Such a framework also benefits struggling newsrooms, which wouldn't have to choose between aggressively pursuing the news through expensive litigation and having to lay off more workers. In sum, Nevada may be well suited to adopt and reap the benefits of an administrative appeals process with the help of a strong, independent ombuds office. And Reporters Committee supports crafting such an entity in the pursuit of greater clarity around how agencies can apply the law with consistency, enacting guardrails around the discretion inherent in the Act's balancing provision, and preserving judicial resources. Secondly, it is widely recognized that there is a First Amendment right to record law enforcement for performing their duties in public. For instance, the Ninth Circuit in Fortis versus City of Seattle recognized the First Amendment right to film matters of public interest in the context of a man who was videotaping people on the streets of Seattle, including police during a public protest. In Nevada, the Supreme Court has interpreted the Public Records Act to require redaction of officers' faces from body-worn camera footage. The court relied upon Section 289.025 of the Nevada statutes, which states that any photo of a peace officer in the possession of a law enforcement agency remains confidential. Reporters Committee respectfully urges the task force to recommend the legislature repeal or amend this provision to clarify that the act does not prohibit disclosure of body camera footage that depicts law enforcement. Public officials who openly display their identities on their badges for the purpose of fostering oversight of their on-duty conduct. Across the country, law enforcement agencies tend to release body camera footage with redactions when such redactions would protect from disclosure the insides of residences, insides of medical facilities, or juveniles or victims of crime. For instance, recently in Fuster versus Township of Chatham, New Jersey's Supreme Court determined that when withholding body camera footage did not protect any significant privacy interest, it had to be disclosed. The court considered whether victims might be dissuaded from coming forward, whether critical infrastructure would be revealed, or whether deceased individuals would be depicted. It did not consider whether officers' identities would be revealed. In neighboring California, the state Supreme Court has held that when redacting body camera footage for release, agencies cannot shift the cost of redaction onto those requesting public records. In discussing permissible redactions, it discussed medical information and tactical security measures. It did not contemplate redaction of officers' faces. Disclosure of body camera footage, redacted where necessary to safeguard the privacy interests of third parties, benefits law enforcement and the communities they serve alike. A powerful example of this principle is evinced by the recent reporting of the Tribune Democrat, a Pennsylvania newspaper that reported on the shooting at a nightclub. Following the shooting, in which 4 women were injured, the community was concerned about the alleged use of racial epithets by law enforcement. But upon disclosure of the body camera footage, the outlet was able to analyze and report on the footage and assuaged readers that responding personnel in fact acted appropriately and compassionately in carrying out their duties. This case study perfectly encapsulates the philosophy that transparency facilitates healing. In conclusion, Nevada's Public Records Act contains many strengths, and we appreciate the opportunity to be heard on ways to make it even stronger. Thank you very much.
Thank you, Ms. Singh. We appreciate that presentation. I'll open it up for any task force members who have any questions of Ms. Singh.
Mr.
This
Chair,
is Matt Morris. Oh, sorry. Go ahead.
Thank you, Matt. This is Mitch Fox in Las Vegas. Thank you, Mr. Chair. Thank you for your presentation, Ms. Singh. It's very, very informative. This is the ombudsperson. This office was under consideration actually during the last session of the Nevada Legislature. And some of the discussion centered on how this particular person is appointed. How do various states appoint this individual to avoid any kind of a conflict or appearance of conflict? Thank you.
Of course, it's a great question. Setting their term according to statute is one way that an ombudsperson can feel as if they truly have room to do their job. In Indiana, for instance, the way it was done for some time was they were appointed by the governor and remained in that office for a 4-year term set by statute. They could only be removed for cause, so they couldn't just be removed if the governor didn't like what they were doing. Placing them in the legislative branch, as discussed in my testimony, is also an option. And in the federal government under FOIA, for instance, administrative appeals of agency decisions are typically adjudicated by a separate agency office within the same agency that made the decision. My understanding is that FOIA appeals processes left to attorneys general don't tend to be quite as effective as some of the other models I've discussed because of insufficient time or resources to pursue open records requests. But to the extent that the task force wishes for additional information on this issue, would be more than happy to provide supplemental information.
Thank you very much.
This is Matt Morris. Just a quick question. First of all, thank you for the presentation. You had referenced the Connecticut FOIA statute, and I was going to ask a quick follow-up. So does your organization see that as a model for other states to replicate, or are there particular parts of that statute that you think are more effective? I was just going to ask you to elaborate on that, if you could. Thanks.
Sure, of course. The Connecticut Freedom of Information Council has long been heralded as exemplary, but I'll also note that when Illinois set out to strengthen its FOIA law in about 2009, it did so by focusing on making its public access counselor more effective. So the state enabled its PAC, public access counselor, to mediate disputes, issue non-binding opinions, or issue binding opinions after investigating its dispute. And now it's considered one of the strongest open records laws in the country. But since I have the opportunity, I'll also flag, I'm a big fan of Nevada's State Records Committee because it incorporates public and private actors from a variety of backgrounds. For instance, there are representatives from local government and state history, a member of the news media, a governor's designee, and a citizen. And so committees like these really inspire confidence in the outcomes of disputes. In cases where information ultimately is determined not to be disclosed, a demonstration that one's peers concur with government officials can influence a citizen to just end the process there, rather than going to court, which of course preserves judicial resources. So ideally, an administrative appeal committee would include members of the public, media, and government.
Thank you for that. And Chair, can I just ask a quick follow-up?
Yeah, please go ahead.
You may have this on hand and you may not. It's fine if you don't. But you had also mentioned a New Jersey Supreme Court decision, as well as a California Supreme Court decision. And I don't know if you have those citations, just the names of the cases. And if you don't, that's fine. But would you mind just emailing those to us for those of us who are interested in looking those up?
Absolutely. I can also cite them for the record right now briefly.
Great. Yeah, that'd be great.
Sure. So the New Jersey case, Fuster versus Township of Chatham, the citation there is 259 NJ 533 from 2025. And the California case that I mentioned was National Lawyers Guild versus City of Hayward, 9 Cal 5th 488 2020.
Awesome. Thanks very much.
This is Matt Christian in Las Vegas. Again, thank you for your presentation. I just was hoping that you could expand on your comment that body-worn camera should be redacted when appropriate. In particular, you mentioned footage that's from inside homes and inside hospitals. Does your association take any position on whether that kind of footage should be presumptively confidential?
Our position, first off, has never been that every single recording should be released. We absolutely want to find that middle ground in terms of striking the balance between targeted redactions for sensitive information of the type that I referenced in my testimony and that you just alluded to, sensitive information such as juveniles, sexual assault victims, medical information, undercover officers, of course, interiors of homes. These are sorts of information that in Nevada, I understand have at times been redacted, as well as the vast majority of states. So I would encourage public agencies to continue to use their discretion afforded by that balancing test to figure out when information is truly sensitive, when it should be redacted. However, categorical redactions, we do tend to disfavor, as it dissuades agencies from using the discretion they're afforded pursuant to that balancing provision.
Okay, thank you.
Ms. Singh,
Chair.
oh yeah, go ahead, Ms. McCarty.
This is Leslie.
Oh, sorry,
Shapiro
I'm
for the
sorry.
record.
Thank you. I couldn't
If
tell,
may,
I
a
just heard
quick
the voice.
question. No problem. Just a quick question for clarification. You mentioned a Nevada committee that's doing a good job. So I just wanted to clarify which committee that is. If you wouldn't mind repeating that.
I do apologize. I'm not sure I made reference to a Nevada committee. I certainly highlighted aspects of the Public Records Act that are already strong. For example, the presumption of disclosure, narrow construction of exemptions. I don't believe I made reference to a particular committee. Apologies if I was unclear at any point.
No problem. Thank you. I thought I heard a reference to someone in Nevada, some body in Nevada that was doing a good job.
My understanding, Ms. Singh, was you were referring to our task force as a potential body that could review appeals because we have a makeup of local government and press members. Is that what you're referring to?
That would be a design choice for the legislature to make, whether it's individuals comprising this task force or some other constitution, whether the issues are binding or whether they're advisory opinions or whether it's to focus on mediation. But the important point is creating an independent resource that encourages consistency and reduces unnecessary litigation.
This is Ben Lippman. I think maybe perhaps you had misspoken and you were talking about another state. We all here heard you reference Nevada.
My
but when you
mistake.
were...
The Utah. My mistake. Perhaps I said Nevada when I meant to say Utah. Their state records committee has that wide spectrum of viewpoints represented. Apologies if I misspoke.
Okay, just one, Ms. Singh, I want to have some more questions, but I just wanted for the task force and anyone listening in, there's apparently been some technical difficulties with the YouTube link, and I believe a new link is being set up and established. So I just wanted to let everyone know that. Ms. Singh, any other questions for Ms. Singh? I did have one for you, Ms. Singh. I'm curious if you know in some of the states that you've mentioned that use the ombudsperson approach, how are those offices funded?
I don't believe that I'm able to speak to that at the moment. What I would say is a typical public access counselor or ombuds office as a starting point would have about 2 to 4 people. And my understanding is that the sort of personnel records that would be able to inform the task force about how much that would cost the taxpayers, that can be accessed via public record. But again, if needed, I'd be happy to provide supplemental information.
That's okay. I was just curious if you knew, or if they had if they were funded by filing fees with the ombudsperson, or if they were more general fund. But if you don't know, that's okay. We can look. Other questions for Ms. Singh? Okay, seeing none. Ms. Singh, thank you very much for your presentation and your slide deck. It's part of the record now. We appreciate your time, and we'll go ahead and excuse you. You're welcome to stick around and listen to the rest of the meeting if you'd like to. And with that, I'm also going to suggest that unless someone has an objection, that we take about a 10-minute recess so we can just make sure we get the YouTube link up and running for anyone who wants to watch online. So with that, we'll be in recess for 10 minutes. We're going to get started in a few minutes if everyone can start making their way back to their locations. Okay, we'll go ahead and come out of recess and resume our meeting. I understand the new YouTube link should be up and running now, so we should have some online attendees. LCB, I don't know if it's possible on the old link to indicate what the new link should be, if there happens to be anybody still on the old link. If that's possible to do, would you please do that? Otherwise, for anyone listening in, we do have the new link and should be up and running. So with that, we will go ahead and continue on through our agenda. We're now on agenda item 7. This is a presentation from Sarah Bradley, State Bar Public Lawyers. Ms. Bradley is online, and Ms. Bradley, I will turn it over to you for your presentation.
Great, thank you so much for inviting me. I am the chair of the Nevada State Bar's Public Lawyers section, and we were really glad to be invited to participate and to provide some thoughts. I don't have a lot of thoughts that are very new, I think, from what other government representatives have already presented to the committee, but I do have a couple that I wanted to touch on. So one thing that we had thought would be helpful is to add some explicit confidentiality provisions that recognize some of the common law privileges, specifically deliberative process privilege, because I know right now, I think we all use that, but we use it sort of as an other declared, otherwise declared by law provision. So that's kind of where we get it from. And it might be nice to have that included a little bit more specifically for public records. We also want to ensure that there's some consistency with regard to the confidentiality of personnel records and a specific definition for personal identifying information. Right now, I think many of the agencies use NRS 603A.040 and or NRS 205.4617 as guides, but they're not really perfect. NRS 603A.040, I think, is the most commonly used one. Perhaps there's a little more than we should use from there. And then I would say the 205, the NRS 205 provision might be a little broader than we might want. The other consideration would be confidentiality of workplace investigations for state and local governments. I believe for local governments, they're often using kind of that one of those common law privileges about deliberative process and things like that to shield information regarding those workplace investigations. And just so everyone's aware, usually what I mean by workplace investigation is a complaint's maybe been made about one employee by another, and so we bring in an outside person to do an investigation, talk with people involved, to make a recommendation to leadership regarding how to handle that situation and maybe whether or not one person's conduct violated policies. So it's often, I would say, kind of sensitive and, personal information. The other request that I got from some of our members has to do with exceptions in NRS 239 that are there for state government agencies are not always fully carried through for local governments. And then I know there was extensive review of costs in 2019, and I don't want to bring up something that I know is controversial and challenging, but basically right now it says actual costs, and it does kind of define it, but it really defines it only as, paper, toner, things like that. And I do think there sometimes are other costs outside of that that might be helpful. In the past, there was a recognition of, I know, extraordinary use for employee time and resources. I think that was pretty controversial and that was taken out, and I understand that. But I just wonder if there's a way to recognize that. I mean, we have, I work for the Nevada State Board of Medical Examiners now, and I was at the Attorney General's office for 12 and a half years. And I did work on public records while I was there. And of course, here I do as well. And I know, we have a lot of run-of-the-mill easy requests, but then there are those that are really burdensome for the agency and that do maybe require, additional review. I've even heard of some agencies hiring companies to help them with email review, things like that are just really large. And so it might be nice to somehow kind of recognize that and have some parameters. I think the concern in the past was the fees are really high and unreasonable for some requesters, and it felt like maybe I think that was a barrier, meaning that some of the agencies were using the fees perhaps to not provide records. And certainly that's not the intent, but I do think there are times, especially for really small agencies. So some of my clients that I had when I was at the Attorney General's office literally had 1.5 employees. These are independent boards, really small, not a large budget. And so somehow recognizing that not every agency can maybe handle every request in the same way might be helpful. And then I also, this is kind of something really that I'm asking about, would perhaps be maybe some funding for training and updating manuals. So the Nevada State Library Archives and Public Records does do a lot of training. I know I primarily, I believe, for state employees, and they may have things for local government employees, but they also have manuals that I think are really helpful. So they have a manual for executive branch agencies on their website, but it was not updated since August of 2020. They created that manual pursuant to NAC 239.869. And so that regulation says that basically people are to, state agencies are to follow the manual that will be created. So it's kind of adopted by reference. But I think it should be updated, I would say, I don't know, every other year, maybe every 4 years. And so that would be something that might be helpful. I know I helped write that when I was at the Attorney General's office. And, a lot of it is really telling agencies, the administrative members that are providing these records and doing these tasks, kind of how to process them. And I think it was really helpful because a lot of agencies didn't have a lot of guidance before that. And then there is a similar manual available on their website for local governments, but that has not been updated since 2018. I don't know how helpful that was to them, but again, I can picture it being helpful for a lot of local governments, especially the smaller ones. So, the smaller cities and local governments that maybe don't have a lot of resources and even ability to really rely on maybe some institutional knowledge. And so those sorts of manuals, I think, are really helpful because it provides some sort of standard and it provides a resource that's available and public and can be a good starting place, I think, for these agencies as they are responding to requests. And so that's really what we have to offer. We are glad, again, to be participating. And I will say that one thing I had thought perhaps, so our section is able to support legislation potentially. And so there's a process for that with the state bar, but I had thought that perhaps what this group brings forward might be something that the public lawyers section could review and perhaps help support in the legislative session. I think maybe that, again, is a possibility. And so I just wanted to kind of bring that there. We'd have to kind of follow the process the state bar has with the Board of Governors, but hopefully that could be some help. And I'm ready for questions if you have any.
Thank you, Ms. Bradley, and we appreciate the offer on the bill too. Do any committee task force members have questions for Ms. Bradley?
Chair, this is Brittany Walker.
Go ahead.
Hi, I just want to thank Sarah Bradley for presenting today on behalf of the public lawyers section of the State Bar. It's really valuable to have your insight and input. I know you've been involved with the section a long time and are very familiar with some of the challenges that we all face. And so I just want to thank you for your time today. The only question I have, and if you don't have an answer, that's okay. One of the things when we presented to the state legislature, they had asked if we had, for us to look at best practices across the nation. And so I was just curious if you knew off the top of your head some examples we could look at for that have ideal confidentiality provisions in other states, or whether you knew of whether these types of things that you listed are confidential in other states.
I do not have information about that off the top of my head, but I would be glad to confer with my members. I have 8 members on the leadership of the section and see what resources they may have. And then I can also potentially do some research. We do have a person in our section who is not a member of our leadership team, but an excellent resource, in my opinion, regarding public records. And she's unfortunately been ill. And so I haven't been able to talk with her about it, but I'd be glad to try to reach out to her and see what her thoughts would be on that. So I hope that might be helpful. I don't know what your time frame is on getting all these things together, but
our report is due October 31st, but so that there is time, and we'd welcome any that would help. We'll be researching as well, but if you have additional information, that'd be super helpful. And again, I just appreciate your time today.
Thank you so much, and we are glad to be included.
Daily work for the record. Thank you, Ms. Bradley, for that presentation. I do appreciate your time. I did have a follow-up question as you discussed the training and manual opportunities through the Nevada Library and Archives. Can you expand on that a little bit more? Was that in reference to, the fee structure? I know we talked about actual costs and expanding the definition of that right before you mentioned additional funding for training purposes and manual purposes. I was hoping you could just expand on what that looks like.
With regard to the training, I did not intend them to necessarily be joined concepts. I just know from my time, so I've now been in public service, 20 years in August, but one of those years was a law clerk. So 19 years working with state agencies. And I just know there's a lot of them that don't always know what they should be doing, especially with regard to public records. And so I guess my thought maybe is always, if we can provide training and more education and resources and guides, that can sometimes help people be more compliant and provide better responses more quickly, things like that. And so that's just kind of maybe one of my personal maybe thoughts and biases. But when I was at the Attorney General's office, I was actually able to work with the Nevada State Library and Archives and Public Records pretty closely. I actually sat as the Attorney General's representative on the Retention Schedule Committee and actually got to vote, which was very fun because I don't normally get to vote and make motions in my real life. And so I got pretty familiar with the state records retention schedule. I also helped them with a lot of outreach and training. They did several big forums where they would have, for example, I would present, the state records manager would present. These are, of course, pretty state focused, but I do think similar things could happen for local governments. And I guess my thought would be if there was some funding for that, and I don't know that it would have to be a lot of funding, but certainly enough where maybe there are people that are tasked with that could help with a little bit more of that training and maybe more specific training. And then again, updating those manuals and maybe working with local governments to make sure that the manual they have is actually helpful, relevant, complete enough. I just know being here at the medical board, sometimes we get questions from, like small cities, the city of West Wendover, and we get questions from Fallon sometimes, and it's usually their business licensing. But I just know a lot of those smaller governments, smaller local governments, don't have a large staff, and they may not have all the resources. And so this could be really helpful, I think, for them to bring them on board with some of these policies. And then, I think the larger local governments probably have pretty well figured out how they're going to handle these things. So I guess that was just my thought, to try to help, especially the smaller entities. And then again, making sure there's consistency, because one of the benefits of having these manuals, I don't believe that state agencies are required to just follow the manual, copy that's your policy. They're able to have some discretion on what their personal policy is for that agency, but it gives kind of that baseboard foundation, which I think could be really helpful. Because I guess I would like to see more consistency, if we can, with regard to the responses and the training for the whole state.
Any further questions for Ms. Bradley? Okay, seeing none, Ms. Bradley, thank you for your presentation and your recommendations. We appreciate it. We'll go ahead and move on to the next one. You're welcome to stay online and participate. We'll move to agenda item 8. This is a presentation from the Nevada Department of Transportation, and that will be an in-person presentation from Carson City. Welcome. Please go ahead and identify yourself and proceed.
So much, Chairman Hicks. Just out of curiosity, before I start, I submitted my presentation to the task force. Will that be available for the members to view?
I know we received
we have it. It's in the backup material.
Are you looking to have that put up on the screen while you're speaking? Because we can see if we can do that.
It's not necessary, as long as the task members have it available for their perusal. So again, thank you, Chairman Hicks, and good morning, task force members. I appreciate the opportunity to speak with you today. My name is Heather Hahn, and I serve as the records manager for the Nevada Department of Transportation. I hold a master's degree in Archives and Records Administration, a certification through the Institute of Certified Records Managers as a certified records manager, and I am currently a member of the board of directors for the National Association of Government Archivists and Records Administrators, or NAGARA. In the slides that you were provided in your packet, they attempt to address each of the evaluation criteria that was outlined in AB 128, and so I will go through them by evaluation criteria or element. So evaluation element number 1. As the task force is aware, there are numerous exceptions to NRS 239. I would like to focus on 2 in particular: NRS 242, Information Services, and NRS 239C, Homeland Security. Under NRS 242, agencies may classify certain cybersecurity-related records as confidential for Homeland Security purposes. However, due to fragmented communication and limited cross-agency coordination, public records staff are often not informed about which records have been designated as confidential under NRS 242.105. In addition, several definitions in NRS 239C lack clarity, making it difficult for agencies to determine how specific provisions should be applied related to Homeland Security. For example, NRS 239C states that records concerning critical infrastructure must be kept confidential and provides examples related to emergency management. Yet NDOT maintains records of physical critical infrastructure, including records related to assets such as the Hoover Dam, Harry Reid International Airport, and other essential facilities within our right-of-way where those records are created as part of the normal operational responsibilities of NDOT rather than for emergency management purposes. With clearer statutory definitions, especially regarding technology infrastructure and stronger requirements for cross-agency collaboration, public record staff would be better positioned to protect sensitive information for the security and safety of Nevada residents and visitors. Moving on to evaluation element number 3, I have not included evaluation element number 2 as it pertains specifically to law enforcement records, which is outside of my purview. Broad public records requests significantly hamper an agency's ability to respond in a timely manner to all records requests. As my fellow presenters have noted, vexatious requesters whose patterns of behavior suggest an intent to overwhelm or obstruct further burden the system already challenged by rising records request volumes. At the federal level, this type of behavior has been identified as FOIA bombing in an attempt to overwhelm the agency through excessive and repeated requests. The positive operational impact that we've seen of such requests at NDOT has developed a formula to determine necessary deadlines to complete a request. The formula takes into account the number of records to be reviewed, the average review rate of the NDOT public records staff, and the available hours to complete the request weighed against the outstanding workload. As far as I'm aware, I don't believe this is a consistent approach done by other government agencies. However, the small operational improvement does not outweigh the significant increase to requests. Between 2023 and 2025, NDOT experienced a 33% increase in public records requests. Current projections for 2026 are estimated at approximately 1,680 requests to be received in 2026, representing a 56% increase over 4 years, without additional staffing or resources being provided. Broader vexatious requests intensify this strain. For example, over a 2-year period, NDOT received 34 requests, which only constituted approximately a 2% of all requests received, from a single individual who declined to narrow the scope of any submission they provided. These requests required review of approximately 200,717 documents, not pages, documents, by NDOT public record staff. It should be noted that one of the 34 requests required the review of over 130,000 records. Based on staff's average hourly review rate, they completed the work associated with the 34 requests. The work associated with the 34 requests would require an estimated 8,028 staff hours to complete, amounting to a minimal cost to NDOT and to the state of $152,545 in personnel time. We are able to calculate that minimal cost because NDOT employs staff who are tasked with processing public records requests as their primary job function. As Ms. Bradley mentioned, not every government agency is lucky to have staff available to process their public records requests. This case illustrates the substantial time and financial impact that overly broad or unrefined requests can impose on an agency, particularly when the requester refuses to narrow the scope. As a side note, I'd also like to mention another trend that we are seeing in requests that they appear to be coming and written by AI, in which the language model takes an overly broad approach to the records request. Again, just a side note, a current trend we're seeing. Evaluation element number 4. The greatest cost to government agencies arises from the staff time required to review every page or record for confidential information, a process that remains entirely manual. NDOT is fortunate to have dedicated public record staff. However, as I mentioned, many government agencies do not have such resources. Public records processing is one of several responsibilities assigned to staff. In addition to staffing costs, agencies must also maintain software licenses, specialized redaction tools to support effective review and redaction. To date, there has been no effort at the state government level to identify an enterprise-wide solution or shared resources to reduce the burden across agencies, as far as I'm aware. Regarding time constraints, it is important to note that there are simply limited hours available each week to complete the necessary work. NDOT currently employs 3 full-time staff dedicated to processing and reviewing public records requests, representing a combined total of 6,264 available working hours annually. Based on the calculation presented, completing the 34 requests from the earlier example would require more than a year of combined staff time to complete that request, or all 34 of those requests. Ultimately, the greatest cost, burden, and operational constraint lies not in the act of redacting a record, but in the extensive review necessary to ensure that confidential information is properly protected. To advance timely release of public records, more dedicated staff, interagency collaboration, effective technology solutions, and operational resources are needed to put public records on a solid footing to meet the rising needs of the public. Evaluation element number 5. If a standard fee schedule were adopted, particularly one that incorporates the cost of staff time, it would result in a certain amount of financial impact to requesters. Currently, government agencies may charge only actual costs, which at NDOT generally applies to physical media such as copies or flash drives. However, the nature of the public records request process has evolved, and agencies rarely produce records in that format. Delivery of requested records is done through email or some other means of digital delivery. Establishing clear parameters within a standardized fee schedule could help agencies recover extraordinary costs while still allowing requesters to seek exemptions based on their ability to pay. This approach would support fairness for the public while also providing structure to the public records request process. Importantly, it could also serve as a reasonable deterrent to vexatious requesters whose overly broad or excessive submissions place a disproportionate burden on agency resources. Element number 6. Currently, Nevada does not have a formal mechanism to resolve disputes arising from public records requests. In contrast, neighboring Utah has established the Government Records Access and Management Act, colloquially known as GRAMA, which provides structured processes for resolving disputes in a manner that supports both the requester and the government agency. Under GRAMA, the Government Records Office, or GRO, plays a central role in evaluating potential vexatious requesters through an objective and consistent framework. The director of the GRO is responsible for reviewing the number of requests submitted by an individual, the scope and subject matter of those requests, the tone and frequency of related communications, and any patterns of abuse or actions that impede an agency's operations. In addition, the GRO administers the Public Records Ombudsman Program, which offers mediation services to help resolve disputes in a fair and impartial manner. You may have the printed version of my presentation. However, if you are able to get an electronic version, a link to Utah Code Chapter 63G-2, which is the Government Records Access and Management Act, is available in the slide deck. The establishment of an agency similar to Utah's Government Records Office would provide consistent structure, shared terminology, and centralized operational oversight for the public records process across Nevada. In turn, it would help reduce communication gaps, minimize inconsistent legal interpretations, and offer public records staff a unified resource for guidance and support. Element number 7. While I do not intend to address every subsection of evaluation element 7, I would like to focus on 2 that have not yet been discussed. Penalties imposed upon government entities and retaliatory litigation. Implementing penalties for agencies without first establishing a clear mechanism for guidance and oversight would place government entities at a significant disadvantage and could result in an increased volume in litigation. Creating standardized guidance, enforcement, and oversight before penalties are considered would help ensure that both requesters and agencies operate within a fair and consistent framework. A similar approach may be applied to concerns about retaliatory litigation. Each establishing a public records oversight office, one that provides mediation and support for both requesters and agencies, could help reduce adversarial interactions and limit situations in which litigation is used as a retaliatory tool. So in conclusion, as members of the Public Records Task Force, I urge you to recommend policies that ensure robust public access to government information while thoughtfully balancing the protection of sensitive data. By advocating for collaborative practices amongst requesters, agencies, and oversight bodies, you can help establish a resilient and equitable public record system that empowers Nevada residents and safeguards the state infrastructure. Thank you again for the opportunity to speak with you today, and I hope the information and practical examples I have shared will support you in developing your recommendation report. Thank you.
Thank you, Ms. Hahn. We appreciate your presentation and your written materials as well. Are there any questions for Ms. Hahn from the task force?
This is Ben Lipman. Thank you again for your testimony. We really appreciate you taking the time to come down here and speak with us. I had a question about the retaliatory litigation. Can you give us specific lawsuits that fall into the category to you of retaliatory litigation?
Thank you, Member Littman. Unfortunately, no, I can't give you any examples off the top of my head. However, I'm happy to go back and do a little more research, and compile a list if you would like.
Thank you.
This is Matt Christian. Oh, sorry.
Ms. Hahn, I do have a question for you. You concluded with kind of discussing a collaborative approach with requesters, between agency and requester when they make their submissions. Do you have any best practices that you can share, perhaps how your office or similar offices conduct their business collaboratively with requesters?
Thank you, Member Burke. I can speak to NDOT and our process. We try to make our process as objective as possible, hence the formula that I mentioned in my presentation, where we're not leaving it up to the interpretation of the records staff. The other side of that coin is when we do get a request from the public, especially the broader requests, because NDOT deals with very technical records such as road construction documentation, infrastructure plans, that sort of thing, we will work with the requester as best we can to help guide them to identify exactly what record they are looking for. And that really starts with the form that we have on our website that allows, so the way the form is structured, I should say, we've identified, I want to say, possibly 10 to 15 of the most commonly requested records that we get. And so we've turned those into checkboxes. So requesters can check the box of what they're looking for. Then we also have an additional selection of other, where if they're not sure where they can or what they're looking for, they can identify what they think they're looking for, and then provide a little bit more of descriptive information to help narrow the scope of their request. But ultimately, too, after the request is submitted to us, the NDOT public records staff is diligent about working with them to really narrow down and hone in on what they're looking for, to make sure that we can make the process as expedient as we possibly can.
Excellent, thank you.
Other questions for Ms. Hahn?
Yes, this is Colleen McCarty for the record. Thank you so much for your presentation today. And just following up on some of what you just said, when you have those categories of frequently requested records, have you all explored at all just posting those types of records to your website to avoid having to fulfill the records requests?
So I can give you an example of one particular record type that that discussion has got off the ground a little bit this spring. We maintain a record that's called an as-built. It's basically the end result of when construction work is done. It documents any changes from the beginning of a project to the end result of a roadway. And those typically, under the current law, don't contain any confidential information. And so there has been a conversation about putting those out onto the website for public consumption. Where we are now is trying to navigate the technology constraints that are available to us, not having the technological resources or figuring out what technology resources would be able to accomplish that. In addition, we need to make sure that every single as-built, which is a blueprint in essence, is ADA compliant, which is also another challenge that we're working through so that we can be compliant with the ADA requirements as well. I will speak, though, to your question, Member McCarty. Other states that I have seen do something similar. I believe the state of Washington, their Secretary of State's office, they maintain or process a large quantity of their public records requests, and they do maintain a online database. I don't recall if it provides all of the records that were requested, but you can see what public records requests have come into the agency over the course of time.
Can I ask a follow-up? If you were able to do something, thank you. If you were able to create some kind of database like that, would that largely assist with the burden of public records requests for your office?
For the documents that have non-confidential information in them, the routine documents, potentially yes, because that would assist our contractors or engineers doing work with NDOT. Where we tend to see the most overburdening of the department is when it comes to email communication. And for example, the example I gave of the 130,000 documents or records that were identified, that is because the requester asked for an individual's entire email account from a beginning and end date, which resulted in 130,000 emails, attachments, everything that goes into the email process. And because those aren't consistent, that does require the review and close review by public records staff to ensure that no personal identifying information is released or any other confidential information that could be in those emails.
And is NDOT employing any software at this time to assist with that kind of a review? Or do you have any software that you're using with respect to your public records responses?
So our, we do maintain a software, and I don't know the ownership of that software, because it is also utilized for our e-discovery process, and by our Attorney General's office. But what that software allows us to do is it allows us to collect and store the identified records in a kind of in a case management system, which then allows the public records team to go in, redact the confidential information, identify why the redaction is being made, and then export it in the PDF format to provide to the requester.
So it's more of a storage system versus a sorting system. Is that right?
Correct. It's a case management system. It's also used, again, by the Attorney General's office, I believe, to help with their case management process. And it's utilized by our team in order to be able to visualize those records, because it does allow, say, an email message, which is an MSG or an ELM file type. It will allow us to view all of that easily, so it does help with that conversion. Then once it's in the system, that's when it kind of becomes the storage location while we're doing our review.
Great, thank you so much.
Chair, this is Matt Morris. I just had a quick follow-up.
Go ahead.
Thank you, Ms. Hahn, for your presentation. I had a question about the example that you referenced in your presentation. I think you said that one of the more onerous requests that the agency had received would cost something like $150,000 basically in staff time to review. Is that right?
Correct. The exact number is $152,545, and that is the minimum cost. That is the cost for one of our public records staff members to work on those 34 requests based on their base pay. As at the state level, they're classified as administrative assistant 3s.
And is the agency, or has the agency in the past gone to the legislature as part of the budget process to, identify these costs or identify the need for more staff? Has that ever been part of the discussion?
Unfortunately, I can't speak to that. I myself have not been a part of leadership discussions that potentially were or have been taken to the legislature. The only conversation that I've more been a part of in regards to the legislature is related to confidentiality and that critical infrastructure that I mentioned related to NDOT records.
Okay, thank you.
Other questions for Ms. Hahn? Okay, seeing none.
Chair,
Ms.
this
Hahn.
is Leslie Nino Piero.
Go ahead.
Good morning, Ms. Hahn. Thank you so much for your presentation. I have two questions for you. The first is on the ADA requirements that you mentioned. Can you expand a little bit on that and tell us what that, tell us about that requirement? And then within your agency, what goes into making records ADA compliant?
So I believe it's, I won't be able to cite the federal reference off the top of my head, so I do apologize. But there was a deadline given to government entities that was postponed from this last spring, so I believe April of 26 to April of 27, that requires anything that is out on a government public website be accessible to anyone with a visual impairment or any other disability that would impact their ability to interact with a government website. And so part of that is then us moving towards making sure that all of our, not only the website content, but the documents that are published on the website are ADA compliant. I myself am not an ADA compliance expert, though I am happy to get you the contact information, at least of the NDOT ADA expert that we have on staff. But my understanding to make records specifically compliant on a website is they need to be remediated to a point where a screen reader can read the document aloud to someone with a visual impairment, and also indicating photographs, making sure photographs have alternative texts so that can also be read out by the screen reader, and also allowing anyone who might have any sort of difficulty physically interacting with the website, giving them the ability to navigate easily, based on their physical limitations. Does that answer your question, Member Nero-Piro?
Yes, thank you so much. Chair, a quick follow-up, if I may.
Please go ahead.
So I really appreciated your the figures that you provided about the increase in requests, and then talking about the changes that we have started to see in government agencies having to do with AI. So I was wondering if you would talk a little bit about how AI has changed the complexity and the character of the types of requests that we're receiving, or that your agency specifically is receiving.
Of course. I wouldn't necessarily say it's changing the complexity of the request. What it's doing and what we're seeing is requests from different people who, as far as we know, don't have any association with each other. So, for example, members of the public versus engineering contractors, and maybe somebody from a utility, or, very wide range of requests. They all have the same language. And what I mean by that is it is broken out pretty much almost verbatim the same, maybe some little changes here and there, which leads us to believe that AI is writing those requests. And then because the requester may be unsure of what they want to ask for, they are taking what AI is telling them as correct or accurate, and submitting that to us, not realizing that when the AI system puts in the phrase any and all records related to whatever the subject matter might be, that is creating a very broad request, again, depending on what the subject matter might be.
Thank you so much, Ms. Hahn.
This is Matt Christian. Again, thank you for the presentation. I just had a follow-up question about the requester that you had mentioned earlier that wants all of the emails. I'm just wondering if there's any indication of who that person is, not by name, but I'm just wondering if your agency knows what the purpose of the request is or what the motivation is. Is it a contractor or just a citizen? Do you know what the need for all those records are by that requester?
Thank you, Member Christensen. Yes, we do know who the requester is. And so that I am not speaking out of turn, I would say, I would only say that this requester is potentially party to civil litigation with NDOT. And that is how we became aware of them and their identity. But we do also have other requesters that are not in that arena with NDOT that we might know who they are by name, email, and organization only. We don't know beyond that who they are. Yet they are also sending us requests that are either overly broad or in some instances, in the example that I gave of the term FOIA bombing, that at the federal level, we will have requesters that will request records of information that they know we cannot provide. And so I don't know what their goal intent behind the request is. That's not our place to interpret. But they do lend to the challenge of fulfilling and helping all requesters when we have to focus in on those requests that are asking for things like, for example, computer IP addresses, key card ID, RFID information, any sort of technical identifiers in that regard, that we have to go through the documentation with a fine-tooth comb to make sure that we don't release that information. Especially learning from the example last year with the hack on the state.
Okay, thank you.
Any further questions for Ms. Hahn?
Yes, Colleen McCarty again for the record. Ms. Hahn, not speaking about any particular request, but just generally, what is your process when you get a request that you feel is not narrowed or tailored in any way? What process do you use to get with the requester to try to sort that out?
Of course. When we receive the request, my team reviews the content of the request, making sure to identify that somebody has actually requested records. Sometimes requesters will submit a request and they're just asking for information. They're not actually asking for a record to be provided. So we'll work through that with them if that's the case. If we notice that their request might seem overly broad or they're using terminology that we don't necessarily recognize at NDOT, we will reach out to the requester and ask for clarification. And that's their opportunity to provide us more information, or it goes to that collaborative approach that I mentioned in my presentation to work with the requester to really hone in on what they're looking for. And so we help them get to where they want to be or what they're looking for. From there, I'm going to backtrack for just a moment. For the requests, say related to email, where it's asking for any and all emails related to a subject matter. What we will do is we will run our search first to produce a solid number of records that have been identified in the search process. We will then let them know these are the amount of records that came up in our search results. We will also do a preliminary deadline calculation based on the number of search results that came back using the calculation that we have established to give them an expected deadline. And that's usually another avenue for us to start the conversation with the requester to help them narrow the parameters of their request, especially when it comes to email or any other sorts of correspondence.
And do you ever just reach out before you do all of that work to see if there's some common ground that can be found there? Or is there a reason that you feel like having that information helps to drive the conversation in some way?
It's a little bit of both. So we will start the conversation with requesters prior to running the search. It really depends on the request itself. For the especially again the email, the correspondence requests that tend to have the language of any and all or all emails related to a subject matter. It's been our experience that they tend to produce a large quantity of search results. And so in order to make the process more objective, we want to be able to provide that information to the requester so that they have the same information that we have, and are able to make determinations on whether are they okay waiting until the deadline that we've provided. If so, then we would move forward, not narrowing the scope of their request. Ideally, though, we hope that they will narrow the scope of their request, because another trend that we've seen along with AI is there are some requesters, mainly more members of the public versus engineers or contractors. They don't really know what they want, so they ask for everything. And through that collaborative communication process between the public records team and the requester, we're able to really hone in on what they're looking for.
And are those conversations typically had by email, by telephone?
Typically by email to start, but we will reach out to requesters by phone if we feel it's needed, if it's easier or it's going to be more productive to communicate via phone.
Thank you.
Other questions for Ms. Hahn? Okay, seeing none, Ms. Hahn, thank you very much for your presentation and your availability to answer questions. We appreciate it. We'll go ahead and excuse you. Thank you. Mr. Christian is, as the representative of the Las Vegas Police Protective Association, is he present and ready to go?
No, he is not.
Okay, do you have any indication of whether he will be present today, or should we just move his presentation to a future agenda?
Yeah, I think we can safely move it to the future agenda.
Okay, well, with that, we'll move agenda item 5 to a future meeting and agenda. As discussed earlier, agenda items 9 and 10 will also be moved to a future meeting and agenda. That takes us to agenda item 11. This is the substantive discussion of the task force work of preparing evaluations and recommendations. I know we had some discussion regarding the template last time. I'll go ahead and open it up to task force members if there's particular issues they would like to discuss today, or whether we use the template or not. We are getting coming up against our end of October report deadline, so we do need to start narrowing some of the issues and recommendations that we're going to be thinking about. I will say that Vice Chair Work and I had a discussion during the recess where we both agreed that we would be willing to start taking that template and putting it into a report form, and bring something back to the task force at our next meeting, with an idea of identifying issues, that we could then look at, in terms of where do we have consensus, where are there issues where we may not have consensus, but we still want to identify them for the legislature to think about. So I thank you, Vice Chair Work, for being willing to do that. If that works for the task force, we can do that. But I'm open to any other suggestions anyone may have as well, or any issues anyone wants to talk about.
This is Brittany Walker. We too have, government members have all talked about us individually looking at the report or portions of the report to bring back to the body. But I think that it would be valuable to use this time we've set aside to kind of discuss some of what we're tasked with evaluating and making recommendations on, and maybe even just focusing on evaluations. For example, looking at three of the draft report, impact of broad public records requests. I think the government members could all put some comments on the record for our respective agencies about how that's impacted us, and sort of have some talking points for evaluations there, and on down the line.
Well, that'd be great. Ms. Walker, do you want to make some of those comments now so that we can get them on the record?
Sure, I'll kick it off. I'd be happy to. Thanks, Chair. Brittany Walker, for the record. So I would just say with the impact of broad public records requests, we too have experienced difficulty with that. We also, similar to the presenter was saying today, will get requests for any and all emails related to X. And we have a system where we can search through all our emails agency-wide, and we'll run keyword searches, and it yields thousands and thousands of emails. And some might be relevant, some might have like a common name with somebody attributed to the request and have nothing to do with the request. So it takes time for staff to go through the records and deliver them responsive, and to deliver the ones that are responsive. And we don't save emails, and all our emails are in like Outlook format, right? So for each record that's responsive, so that the requester can easily read it, because obviously if you don't have Outlook, or even if you do, you might not have the ability to like open that file. So we change it to a PDF to send to the requester so that they have it as a readable file. And of course, if we yield that, we'll contact the requester and say, hey, that just yielded thousands of results. We can go through them for you, but it's going to take a long time. And there could be fees associated. Is there something in particular or a way you want to narrow it? And sometimes they will, and sometimes they won't, and so if they don't, we do have to go through and take that time to look through everything. And that if there's privileged types of information in there, that could take my review. And that I'm one attorney for Boulder City. We don't have, other than a contract criminal prosecutor, we don't have other attorneys. And so I have a lot to do in my day job, not just processing records requests. So it does take me away from my other responsibilities to try to get those records out. And we try to do it within 30 days. For more extensive requests, that can take longer, but we do try to get them out pretty timely. And so we try to get them out as soon as we can. And so those just can be burdensome. And especially when the requester really only is looking for something in particular, but they're not, for whatever reason, corresponding with us. And so those are just, again, especially for smaller agencies who don't have a lot of staff, those can really take us away from doing what we're tasked with in other, aspects of our jobs. So those are my just initial comments on that topic. Do we want to go topic by topic, or do we want to stick on one topic?
I think I think my thought now is maybe what's top of mind for people could be brought up, and then maybe we could run through the statutory categories to see if there's comments on each of them.
Well, okay, well, I do have other comments on other categories in the report, but I didn't know if you wanted to allow other members to make comment on the broad records requests. Because that is in the statute. That's.
Yes, I appreciate you bringing that issue up. Why don't we tackle broad records requests right now, and then we can move through some of the others as well.
So this is Matt Christian. I'm happy to try to speak on that issue as much as I can. I think the comments from Heather Hahn were very insightful. In particular, I think when she gave us an example, a very specific example of one of the requests or a series of requests that they're struggling with, I think that is really the best way to analyze this issue. The examples that come into my mind immediately just from the recent past at the Las Vegas Metropolitan Police Department are several. We have one current request that we're struggling with where the requester originally sought a list of every event number from the beginning of Metro until present. We had a similar process that Ms. Hahn described, where we reached out to the requester. We explained the virtual impossibility of producing such a list. We described, the size of our organization, the challenges that we would face in producing such a list. She eventually agreed to narrow the request to a 5-year period. And our public records staff worked with our analytical section to determine whether that would be doable. So there was really quite a bit of back and forth between the requester, our public records staff, my office, and the folks at Metro who could actually accomplish the production of a large list of event numbers. So the process went on and on for a little while. We finally realized that it was theoretically feasible to produce lists of, I think, in 6-month chunks without the computers crashing. So after we figured that out, we were able to get spreadsheets for 6-month periods. But the way the database generated the spreadsheets, I think were 50 some columns of information, and there were tens of thousands of line items. And some of the columns contained at least partially confidential information. So the problem became individually going through each cell, which there would be millions of cells in each of the spreadsheets, or trying to get the requester to agree to just remove some of the columns, which is where we sort of ended up. But then even the process of removing a column from such a large spreadsheet turns out that may crash your computer. So it was just a very difficult process trying to get through the production of such a large list. I have another requester, I think that would fall into the FOIA bombing category. And I think I mentioned him in a previous meeting, but he is someone who's disgruntled with Metro. There's no other way to describe it. He had been arrested for domestic violence against his juvenile daughter, I believe. We had possession of his mugshot. At the time of the request, which came from his former wife / guardian of the victim, the juvenile daughter, she requested his mugshot. And because the Metro would normally give the victim criminal history information, including a mugshot, she received the mugshot. Then she proceeded to post it on social media in their home country of Brazil, which apparently caused him a lot of heartache. And in response, he began sending public records requests to us. And we know for sure that they're AI generated just by the nature of them. We did have many records that we provided to him about his own case. In particular, we thought he was most interested in finding out who at Metro was the person who agreed to provide his mugshot. So we were able to figure that out. We provided that information to him, but it's just never been satisfactory to the point of him initiating a lawsuit that's currently pending. So that's an example, I would say, of we did everything we can to try to provide him information. We understand that he's unhappy. Internal Affairs looked into the issue, but there's no, you just really can't be satisfied. We also struggle with emails. Our process is very similar to what was described, I think, in here already. If we get a request for every email between X date and, well, sometimes they don't have dates, but if we get a request for emails, our public records unit will sort of look at it and try to make an early determination of whether it's going to be feasible or not. Sometimes we will use Outlook to run a query to determine how many potential hits there are, and we may often give the requester that number, just so, like Ms. Hahn described, to make sure that everyone's on the same page. And then we attempt to engage in a discussion whereby the requester might identify more specifically which person at Metro. We have over 6,000 employees. So we try to narrow down whose email accounts to look in. If these emails are with someone from outside the agency, we try to get the requester to give us a specific email address, because that apparently makes searching a little bit easier. We try to narrow the dates. We try to do everything we can to make it more doable. And sometimes we're more successful than other times. The other one I just jotted down here that I was recently personally involved with was a request for information about pursuits. It's a national reporter. She had sent the same request to law enforcement agencies across the country, because she was doing a story about police agencies engaged in pursuits. And in particular, she really wanted to know how many deaths, the request read, how many pursuits end in death. So that was a little bit difficult for us, because we don't keep a statistic of that. We keep the statistics of pursuits, and that's published in our annual report that anyone can see online. But it doesn't account for exactly what happened as a result of the pursuit. So we struggled with this request because there was no record that existed that was responsive. There was also a struggle because what does it really mean to end for the pursuit to end in a death, could that be the officer dying? Could it be the subject that was being pursued dying? What happens if an officer commences a pursuit for a couple seconds, and which does happen, then the pursuit is called off, but then 10 minutes later or 15 minutes later, when the person is still fleeing, even though no one's chasing him, what happens if he crashes at that point? Did this requester mean to include that or not include it? So we had a lot of back and forth with her, doing everything we possibly could to try to figure out a way to comb through our records to find numbers that would assist her. But it just eventually turned out that there was too much data. There wasn't any way where she was willing to provide additional information to us so that we could try to narrow it for her. And so that she more or less told us that her deadline passed and she needed to just, I'm not sure what she did, but we sort of gave up. So that was disappointing. We would have loved to have been able to provide her more information, but the effort that we undertook was it turned out not to be successful. But we struggle with the volume. We struggle with certain requesters who seek voluminous requests on a regular basis. I think sometimes if there's one request with 100 subparts, a requester believes that it would be better to send 100 different requests instead of one with 100 subparts. So that's kind of an issue. The volume has gone up over the years for sure. I don't have the statistics, but I'd be happy to try to provide them. We have a staff of, I think it's 6 detectives, commissioned law enforcement officers, or maybe it's 7, and 5 or 6 civilians who work in our public records unit on an everyday basis. The main record that's being sought on an everyday basis are arrest reports, which are, they're documents, and our staff, and that's from the media. So our staff is accustomed to pulling those as fast as possible. The event is usually in the news at the moment. And I think we try to prioritize those, and we don't charge for those, even though I believe that we could. But we provide those on a continual everyday basis. But then you have these other requests that come in that it's hard to know which one to prioritize. Is it today's event, or is it this project that might take several months? So that is an ongoing concern. I guess the other thing I would just mention is the body-worn camera requests. This is what our commissioned detectives are working on every day. They're several months behind. To my understanding, the last time I checked, and I'm checking on this again right now, the vast majority of the requests that we receive for body-worn camera are from insurance companies and from personal injury lawyers and from insurance defense lawyers who are either litigating or adjusting a claim resulting from an auto collision. So our officers will show up to an auto collision. The parties are there. To my understanding, maybe they might say that they're injured or not injured, or that it's my fault or not my fault. So the parties that would be involved in adjusting the litigation are interested in obtaining our body-worn camera for their purposes. I would contend that there's no public purpose in that at all. And it's really just a private matter that they are, trying to, in good faith, they need to adjust it, right? They need to do their jobs too. So we certainly provide those records, but we sometimes struggle with if comes in the form of a public records request, would we provide gory, gruesome images of people's, bloody bodies to the public, or is it okay to provide it because we know it's not going to the public, it's just going to these certain requesters. We do charge for those requests. And again, I'm checking on this again now, but to my understanding, the requesters they fully understand that it's worth it for them to pay for this video. And that's just been our practice for many years now. As opposed to those requests, if we receive a request from the media or anybody for body-worn camera that is about a newsworthy event, and we've received many requests for the same video. For instance, with regard to the officer-involved shooting yesterday, where our officer died in the line of duty, we've already begun to receive all the requests for those records, including the body-worn camera. There will be endless hours of video. So if the requester seeks something blanket like all video for event number, whatever the event is, or all the video from the shooting yesterday, then the issue will be that the volume is too massive. There's too much that might have to be redacted, including officer faces. So the approach that we've taken with that is, which I think has been very successful over the years, the approach we take with that is that we will provide eventually, as long as it's not interfering with an ongoing investigation, we'll eventually provide video that is more of the seminal points of the video, and we'll do that for free and post it on our YouTube channel, but we will not produce the other hundreds and hundreds of hours of officers setting up barriers or standing at a post for hours after the event. So that's been our approach with that. And of course, with a shooting like that or any other critical incident, the department for many years has provided the most important video, the video of the shooting itself, at a 72-hour briefing that will occur in this case probably on Friday, within 72 hours of the event. And to my understanding, that process has been duplicated across the country because it provides the public with as much transparency as possible within that very early period. But at the same time, again, there'd be way too much video that wouldn't really be of any interest. It wouldn't, it's so past to the actual event, but still tied to the event number that we would not ordinarily be even equipped or able to provide that volume of video. So I think that pretty much covers what I would say in terms of the impact that the agency, the impact to Metro on a broad public records request.
Chair, this is Leslie.
No, please.
Well, before I start talking about the impact on the Attorney General's office, is there something you was important to say in response to Mr. Christian?
This has been, I don't want to suggest that it has any importance or that it's any more important than what you have to say, but it was in response to what Matt said, if you want me to do that. It just, in listening to it, it sounded in most of the examples like the process was working, that things got narrowed and the information got produced, or in the instances when it wasn't produced, it was the requester who finally, I guess, gave up rather than it being because there was some problematic impact on Metro that ended the interaction. So I'm glad to hear that it sounds like really the system was working for those, even your most egregious examples. And of course, I'd want us to be careful, even in situations where there might be some argument that there was some serious problem caused, in those rare instances, that we not let exceptions dictate what the rule is rather than recognize them as exceptions. And if there's a way to deal with them, great. And if not, like anything, we deal with an imperfect system when it's still the better of the alternative systems.
Chair, may I just offer some additional comment in response?
Please go ahead. Please go ahead.
Brittany Walker, I just want to point out that I think the key for this evaluation item is really just to talk about the strain on government resources, because we're not allocated funding for responding to public records requests, and we have, as local governments, other obligations in state law and in our functions as agencies that we have to dedicate staff to. So I think the idea isn't that it's necessarily a problem that there needs to be a response and that we shouldn't provide the records, but an acknowledgement that it's a strain on government resources and that there's not funding allocated for that. We have competing priorities, in state law. We have the obligation to, of course, allow our records to be open for inspection and produce records. But we also have obligations for me to prosecute crimes and staff the city council meetings, review every contract for the council, just other things like that. So I think that the takeaway is really just to quantify and describe what the impact is of the broad records requests. And I did want to point out for the others to think about, one of the things that Matt pointed out was that people request information. They don't necessarily request a record. They say, I want all hot pursuits that ended in death. There's not a record that says, oh yeah, we have our hot pursuit that ended in death report here, So if we, of course, try to just work with the requester to find what they're looking for, but that's a frequent issue that we have, is they request information and we're like, well, what record do we have to give you that has that information, or what that, we can't assume we know what they're looking for. So just that distinction as well.
Chair, this is Matt Morris. I just had a quick comment while we're going over the broad request topic, if I may.
Go ahead.
I thought that Ms. Singh's presentation earlier, kind of outlining some of the other state approaches, was really helpful. And I think she emphasized the Connecticut statute, and I just kind of pulled it up while she was presenting, and particularly the administrative avenue for resolving disputes over records. And I think that we should have a portion of this section, and probably each of the sections, that identify some of those other state approaches. I know we talked a bit about Utah today. And I think the Connecticut statute it's modeled quite a bit off of FOIA, it looks like, but there is a provision that is intended apparently to identify vexatious requests. And there's quite a lot of language, helping an agency to deal with something that is truly a vexatious request versus something that's a legitimate records request. So that might be something that we want to include in the report for the legislature to consider.
Colleen McCarty, for the record, we might also look at, there's a statute that addresses vexatious litigants here in Nevada that might be a jumping off point as well, potentially.
This is Leslie Nino Piro. I will talk a little bit about the impact of broad requests on the Attorney General's office. These are just some thoughts I jotted down as Matt and Brittany were talking about their agencies. So I'm going to try to paint visually the picture of how some of these requests come in. There's a form that every single state agency, well, I don't want to say every single one, but many state agencies use, that has a box that asks for the description of the types of records that they receive. Many of the requests that come into our office say, please see attachment. And then instead of describing the types of records that they would like provided within that paragraph or so box, what we get is multi-pages in length. I dealt with one the other day that was 11 pages long. It's not uncommon for them to be 5, 6, 7 pages long. I've had one that comes to mind that was 83 pages long. So that in and of itself should paint a picture of how these requests have become more complex in length, but also in their character, because as Brittany and Matt both mentioned, many are requests for records mixed in with requests for information. So requesters would like data that sometimes we do not package and record in a document or report or something. So in order to respond to their request, we would have to be creating another record. And so that's also very problematic. I think another common misconception is that government agencies can simply, that I go back to my computer in my office and I type in some keywords into a computer system, and then voila, we press a button and we have our search completed. But that's simply just not how government agencies work, and particularly not law enforcement agencies or law firms. There's many, many custodians of records within our office. And the searches are not completed by our team in order for us to have a little bit of independence in how we look at the request. We coordinate with those dozens of internal custodians. So I'll give you a few examples of custodians within our office. We have the IT department, but it's not just one person in particular. We have a gentleman who runs searches on emails. And that is its own, that presents its own challenges just in the emails, as Matt mentioned, trying to drill down into particular domain names, without us guessing or trying to be too interpretive. We try to ask specifically what domain names a requester would like searched. Sometimes we also use search terms, but man, those search terms will can really pull up hundreds of thousands of records that are just not relevant to whatever it is that the requester is looking for. So that's one part of IT emails. We also have our case management system. We have a separate custodian that's going to be looking for case filings. There's multiple administrative divisions within our office. So you have accounting, grants, HR, and then our law enforcement, our investigations unit, and then over 20 legal divisions within our office that also provide services to state agencies. So there's many, so the longer and the more complex these records requests become, they will typically require more and more custodians in our office. And then some of those folks will have multiple databases and some legacy IT databases that they will have to look through. And then when you have multiple custodians, there's certainly the potential for duplicates that just increases the burden on the office and reviewers, because we're trying to parse through what has already been identified as responsive within a review, and what is truly duplicative. In terms of staffing, our office has one full-time legal researcher who that is her main duties is devoted to public records. We also have 6 attorneys who work in administration and review of public records requests, looking for privileges and ensuring that redactions are applied properly. But all 6 attorneys, myself included, as Brittany mentioned, we have many, many other duties besides public records requests. So when you're juggling court deadlines and other internal deadlines, not to mention the public records deadlines, it is very, very challenging and also expensive for our office. And those 6 attorneys that I mentioned in the legal researcher, that doesn't include our, we have over 150 deputy attorney generals in our deputy attorneys general in our office who advise state agencies and do so many times on public records requests themselves. So for instance, if a public records request comes into the Department of Transportation, as Ms. Hahn mentioned, and there's a legal question, she could reach out to her assigned deputy attorney general to ask some question on the Nevada Public Records Act. So I don't have offhand specific numbers, but I'll give you just a little bit of some of my preliminary investigation into this. And in the last 10 years in our office, the volume of public records requests has increased from, in the low teens to well over 200, averaging over, in the hundreds every year. So once we in our office created a matter number to track attorney hours on these items, we were in the low hundreds of hours being expended every year to now more than 2,000 hours every single year that is being expended. And this is just on public records requests that are submitted to our office, not to other state agencies that our deputies would then be assisting with. So even using the very, very low hourly rate that the state has assigned to our agency, we're still talking about a cost to the state of more than it was quantified at roughly $30,000 over 10 years ago, and is now over $300,000 roughly, with just some of the older estimates that I had. And I'm going to be putting together some of this information more fully, but that's a staggering number of, and my office does not charge for public records requests. So we're talking about over $300,000 in legal services that we, or legal time that we're spending on fulfilling public records requests. Because we do have a commitment to transparency, but we also have professional responsibilities that we need to fulfill. And that, again, does not include the time of other attorneys general in our office who are advising their client agencies. So that's a brief overview of some of the burden in our office, and all the time, those thousands of hours that we are spending on public records requests. There is truly a, we're in one sense, there's only 40 hours in a work week. There's only 24 hours in a day. So if we're spending however much time that we're spending on public records requests, that is because there are no dedicated attorney positions in our office, full-time dedicated positions. That's time that is not spent on client matters. That's time that are not spent on other administrative or policy or legal matters within our office. Thank you very much.
Thank you. Does anyone else have comments on the impact of broad public records requests?
I'll be brief.
Colleen McCarty for the record. Oh, go ahead. Sorry.
No, that's okay. I think I brought these up before. I'd really like to see two things. I'd like to see us address the conversation about data aggregators, specifically those that are third-party resellers. Currently, we don't often know who is making requests, whether they are foreign or domestic. We don't know the purposes of the request, if they're selling and to whom. Public records. So I do think I would like to see this body kind of give that some thought for solutions. Also, I do think, we've heard best practices from some of our presenters. We've heard some not best practices from some of our presenters on how different agencies work with requesters. So I'd really like to see us kind of put some thought into how we make it really, really simple to streamline those broad records requests. I do think there are probably some vexatious requests that, it will be a little bit of a challenge. And I'll look at that Connecticut language and Utah as well. But I think we have a duty in government agencies to make it really simple for those requests coming in. And so how do we do that? Some of that is the form. Like I look at it as an Amazon shopping cart, right? Like I know a lot of information that we're hearing is requesters are often seeking information rather than a public record. And so we are often the translator of how do we get from information to a record, right? And so I think there are probably some ways where we can make a reasonable effort to help streamline that up front. That way we're not searching for things that may not pertain to the request. So I just wanted to throw that out there, and I'll put some thoughts on paper on that.
Colleen McCarty for the record. Kaylee, I think you read my mind. My question is just, is there a recommendation in this regard that we should be talking about?
Brittany Walker for the record. Yeah, I think there's a lot of solutions. I think being able to identify the purpose of the request will help us figure out if we had a requirement that the requester provide a purpose for the request, it would be helpful to help us figure out the record they're looking for. I think a requirement on the part of the requester to cooperate, because right now the requirement's one-sided, doesn't require the requester to cooperate. I think a clarification on the government's obligation to provide information versus a record, and what triggered, is information really subject to NRS 239, or is information really different? For example, I think just using Matt's example of the hot pursuits. I mean, was it really their obligation to identify which ones resulted in death, or would the requester just request like the hot pursuits and have to filter through that data themselves to kind of get that, since it's not a record that we keep? Because that's one thing that we have too, is a requester will want information, and in order to give them that information, we'd have to sort through thousands of records, search through the data, put the data together in order to give them an answer, and it's just very time consuming. So just clarification from the legislature on what our obligations are to sort of, we don't have an obligation to create a record, but when they're asking for information, kind of what is our obligation there? I think those are just a few that come to mind. And also being able to require a requester to use a specific form for their request, because under our interpretation, if they make it by phone, if they make it by however they want to make it, that's considered a request. But sometimes, for example, a verbal request is very difficult because we don't have the text to look at, to reference and fulfill that request. So being able to require the requests be in writing would be helpful, or is more helpful would be to follow a specific form.
This is Stacy Lundberg for the record. I would just like to hop on that a little bit with the other speakers on the fact that I think the broad requests as they come in on the form too, that I think we could really benefit from a prioritization schedule, whether it be a direct from a taxpayer, you know, maybe prioritized over a third-party bot, you know, something like that, to make sure that the, you know, I mean, I don't know what would be, you know, how to prioritize that. I would think that a direct response, like you say, for the purpose, and that's going to tell us if it's the requester, if they're a direct person involved in that event, they should be prioritized over a FOIA. Like we got a FOIA request today, and it's 7 different ones requesting the same information from 7 different people. I mean, so, well, yeah, that's kind of convenient that we could send the same information, but it just seems like it's just auto-generating, and we can't auto-generate responses. So I think it would be important to prioritize or have a direction on prioritizing to meet some of the deadlines that are currently in the law.
Other thoughts on overbroad, or should we move through some of our other evaluation criteria?
This is Matt Christian. I was just going to add one thought, and I think this topic, the impact, does bleed over into the costs and the financial burden, which are the next 2 topics. But I think we've heard really great suggestions. I would just simply add that to me, a recommendation would be just a clarification of Nevada law that if the request is overbroad and it is going to require the consumption of a considerable amount of staff time, which ends up being an expense to the taxpayers, either in lost services, like my colleagues have described, or the need to hire additional staff. I think that it would be fair if the law were clear that those costs in staff time would be passed on to the requester. I know that a lot of agencies around the state have determined that if a request is going to take more than 5 hours or 10 hours of time in order to respond to, that is when they will charge for staff time in order to process the request. I think that's very fair. I think that balances transparency with the need to be responsible with taxpayer dollars.
This is Ben. If we're talking about the costs rather than just the size of requests or frequency, and I agree that to have to a certain extent go hand in hand. I think it should be noted that taxpayers already pay for the staff and have already paid for the creation of the records and the maintenance of the records, and they are the public's records and paid for with public tax dollars. And to me, I think the issue is more one of budgeting. If for governmental entities, if they feel that providing these public services and the provision of records are public services that governmental entities have to provide, that like any of the provision of services, that should be worked out in the budgeting process. And if more money is needed for it, certainly by all means, let's provide more money for responses to it rather than foisting those costs off on public records requesters.
This is Leslie Nino Piro. I have a little bit of a different perspective. I understand, and your point is well taken, that these are, certainly systems of records that we already maintain as different government agencies. But I look at this, as I mentioned, there's no attorney in my office that has a position approved by the legislature. Like, they have language for what exactly each position was approved, the job responsibilities, who they're intended to represent. And there's not one single attorney who their full-time job was contemplated by the legislature to be public records. So we are taking time from other duties, from other client agencies, and devoting it to public records in order to fulfill a request. So if that request, without that request, those hours would be allocated differently. Now, I understand your point. This is, well, as I understand your point, it is that the legislature needs to work with the budgets or increase the budgets, create positions. And I think that's a separate question for the legislature to answer. But in terms of having already paid for the request, I disagree with that, because that time would certainly go to other responsibilities and other tasks within the office if it was not devoted to a requester's particular request. So in my view, that is how it is an actual cost to our agency.
Colleen McCarty, for the record. I appreciate that perspective. I think the idea is that we all as taxpayers pay for the government functions. And I think you could ask 10 people which government functions were most important to them, and you would get a different answer. So I don't know that we can prioritize one government function over another. There would be people who would say that law enforcement was their primary government function. There would be people who would say that providing guidance to state agencies would be the #1 primary function. And then there would be people who would say that providing access to public records would be a primary function. So I think that's sort of, I don't know that any of us is in a position to say that one government function is more important than another.
Leslie Nino Piro, I would absolutely agree with you. I think that, you ask 100 people and you may get 100 different responses on what government functions should be prioritized. But in my view, not every person, not every citizen or resident of Nevada seeks public records requests, just like not every citizen would seek a business license or car registration, or there's many, many services that we could identify that a particular subset of residents and would use those services. So I think it's reasonable for us to view this as the folks who are using the service would be sharing in the cost to the rest of the public, because otherwise we are just putting that cost to the entire public when not everyone is using those services.
Kaylee Work, for the record.
This is Matt Christian. Go ahead, Kaylee.
So, Matt, I'll be quick. I think also one thing we should acknowledge too is when we do have these overly broad requests, sometimes they delay those more simpler, urgent requests that we also receive. And so that's something to keep in mind. And when we talk about fees, I'm just throwing some ideas out here. I think I liked where, I think it was Matt was maybe going with the idea of a fee after so many hours as just kind of a reasonable fee for those requests that take an excruciatingly long amount of time. And I mentioned, the reason I say we should probably consider something like that is I think what would be important for all of us, and we will get there later, but with dispute resolution, there's going to obviously be a cost to that. So we should consider whatever our proposal is, how we fund some of these things we'll ultimately ask for will be tough and challenging. And so I think we'll want to work through that.
This is Matt Christian. I just wanted to kind of follow up on our conversation here in terms of what the cost is and how it's accounted for. So I completely agree. It wouldn't be reasonable for an organization like Metro or the Attorney General's office or Boulder City or any of us to not assign a certain number of staff to the necessary purpose of providing public records. And I don't think any of us are really saying that. We know that this is an important purpose. We know that we're obligated to do it. The question just becomes how much of the limited resources are going to be devoted to it. And that ends up being a policy decision. In the case of Metro, there is a budget. It is approved every year. The budget is a limited amount of money that's coming in from various sources, namely the city and the county. And every position is accounted for in that budget. So if Metro has devoted 15 full-time positions, including 7 commissioned detectives, that's been determined to be the reasonable amount of resources to devote to that task. If the number were 16 or 17 or 20, then there would be 1, 2, or 5 positions taken from other areas of Metro and redirected to the public records task. So that would necessarily mean that there would be 1 less detective solving a robbery crime or 1 less officer doing whatever they do on a daily basis, or 1 less civilian assisting the police officers in solving crimes. So there is that cost in that regard. And the amount of resources devoted to it can't be 0, but it also can't be 50%. It's not the main purpose of any one of our agencies is in my case, it's policing. Public records is important, but it's not the main purpose. So it just comes down to how many resources to devote to it on a regular basis. And again, I would come back to, just what is reasonable. If your request is taking, in the case of NDOT, 3 full-time employees an entire year, that seems unreasonable. If the requester really needs that information, then charging for it to me seems reasonable. The taxpayers would then have a funding source to accomplish that task, while at the same time having the original funding source to do everything that NDOT is tasked with doing in terms of giving us roads and making sure that our roads are safe to drive down every day.
Colleen McCarty for the record. So do we need to come up with some sort of a formula as to, based on the number of employees in an agency, how many should be dedicated to this issue? And maybe get the legislature to buy off and fund it?
I think it might just be helpful to distinguish between information and records, because I find the most the most difficulty we have is when the person wants just a broad subset of data that may not be contained in any one record, or if it is, we have to review all those records that can be very time consuming. I would say, this is just a rough guesstimate, but like 60 to 75% of our records requests are, hey, I want this contract, or I want this specific file or whatever. And we're able to just fulfill that pretty quickly. They're not burdensome at all. The ones that are burdensome are the ones that, again, like Leslie was saying, pages long of I want every record related to this, this, and this. And then it takes staff time to even just sort through what it is they're looking for. And you can't make heads or tails of what it is that they want. So I think just having the distinction between information in a record, having an obligation on the requester to work with us and follow a specific format would be helpful, because we might get a request directly to our business license department, and the city clerk's office is charged with keeping all the records requests and keeping a record of those. And sometimes we won't realize a records request has even been made because they were made it directly to our department or a direct staff person. If we could have it funneled through a specific process, I think all those things would really help.
Josh, just one question I had is, listening to when Stacy was talking about getting 7 of the same records requests, and listening to Matt Christian talk about how Metro sometimes gets ahead of high profile body cam requests by putting something up. And this is probably a question for the government members, but how often are broad records requests, or I guess even any records requests, but particularly broad ones, how often are they duplicative? And would it make sense to, we talked about this idea earlier of having like a library or a reading room of public documents, and, would it save time and expense and burden when you have those records requests that come in that are duplicative, or it's very similar to another one, to have like those records are already posted somewhere on a website, or you could just direct the requester to something that has already been fulfilled and say, this sounds a lot like what you're requesting. Can you take a look at that and see if it gets you the records that you're looking for, so we don't have to start from scratch on it? Is that something that could work?
This is Leslie Nino-Piro. I think in theory it could work with some parameters. I'll tell you that the controller's office has done a great job of trying to get information online about the state's expenses and payments to vendors. The purchasing division has a website devoted to state contracts. There's many times where we have received records requests for that type of information, and we will, in our acknowledgement, let them know that this type of information is available on a different state website. And more than once we received a response back, yeah, but you need to give it to us. You need to give us the hard copy, even when we provide links that go directly to the information that they're looking for. So if we were to have some type of, to allow those directions to other websites where that information might be available, maybe we would want to couple that with some language that says that is a complete response, and have the requester make an additional click to view the information there on the website where it's provided, rather than requiring the agency to fulfill it in a PDF or in some other way.
Work for the record. One thing, again, I agree. I think that could make sense in some cases. I handle records that contain personal information that are oftentimes later redacted pursuant to a confidentiality court order. So I would just be cautious of doing so with records that could later be redacted to avoid exposing confidential information.
This is Matt Christian. I think my additional comment would be that most of our agencies probably do a good job of keeping track of requests. So for instance, if we get a request for something in May and then we get a very similar request in June, our public records staff would be able to, communicate with one another and not just verbally, but through our public records portal to determine that we've already answered something similar, and then not have to not have to duplicate the effort. So there is that. Leslie's right in that we've had instances where we've pointed folks in the direction of information that we already make available online, and then they just insist that that's not good enough and they want a hard copy of the record. And I believe that's been litigated somewhere, at least at the district court level, and whatever government agency it was lost. So it's not good enough under the Public Records Act to point to a website, to my understanding, and not if the requester insists. To the point of publishing things online, it's hard to see where, maybe just in our case, but probably in any government entity's case, there's so many records. So which ones would you decide to publish online, especially if they do need redaction? Because you'd be putting all this effort into redacting them and posting them online, and then nobody maybe will ever want them. So I think it would just depend on the circumstances. You might end up posting things and it still isn't exactly what the requester wants. My example about the pursuits is pretty on point because Metro does publish pursuit information on a yearly basis, the total number of approved pursuits, but it didn't have that extra information about how many of them ended in death. So we did point that reporter out to our website, and that was kind of a good start, but it'd be hard to anticipate that we should have included, that more detail in what we already publish, because then next year it'll be something slightly different that we didn't think of. So those are my comments. I mean, I think it's a really good idea. As much as can be posted online, we should definitely do, but I don't know that it's a solution to overbroad requests.
Colleen McCarty for the record. I think there are numerous examples of government entities that already provide searchable public records libraries online that are a wonderful jumping off point to start really exploring this issue. You've got the recorder's office, you've got the Clark County assessor's office, you've got the Clark County clerks that provide marriage licenses, the Nevada Secretary of State that provides business entity registration. There are numerous examples of how public records can be provided in this way that we can look to and expand upon.
This is Stacy Lindbergh. I find actually we're very rural here in Lyon County, but most of all of those records are posted online, and we still just get calls and requesting all the public information that's already out there. So, I mean, I don't think, other than people that know where to find it, know where to go, are really using those rather than just looking to us for a quick response, because taxes are online. We answer 200 phone calls a day of how much do I owe in taxes? So it's kind of crazy. From an example on the election side, I think our Secretary of State has done an amazing job in making our elections transparent and putting everything online for everyone to see. And we still get reporters and requests for information that's posted on that website and updated every 30 minutes on election day. So I can't support, I guess, putting more online that's going to go unused. I don't agree with that. So that's my take on it.
This is Brittany Walker. We too post a lot of our records online. Anything that goes to council, our resolutions, all of our contracts, all those are in a database searchable. We even use Socrata. You can actually look up any check that we've written to any vendor. Just search the vendor and it'll show you how much money we've spent. And so it would be nice in the statute if, rather than having to take staff time to pull that, if we could just, that would fulfill our first obligation if we send like a link to the requester to say, hey, these records are available online. Try searching it first. And if you can't find it, then we'll help you. But it definitely would save us some time to be able to have that be a first step.
Thanks. Other comments or questions about broad records requests? Okay, if not, are there any other of the topics that anyone would like to prioritize? Otherwise, we can just bring them up and see what people want to talk about. Well, why don't we move to, and I guess I should ask, it is 12:18. Does the task force, would you like to take a break, grab a quick bite, or would you prefer to just keep moving?
I wouldn't mind a quick bite. Anybody else?
Yeah, or even just a short break to have some caffeine. Be great.
Okay, well, why don't we recess for say 30 minutes, be able to grab a bite, and then we can come back and keep going. Seeing no objection, we'll go to recess.
Thank you.
Yeah. Yes, I'm hangry. Okay, go grab a bite. I didn't bring my wallet with me. You have like $10 I can buy.
For those down in Vegas, if you're in the room and not up at the dais, please make your way there so we can get going.
There are two of us in the room. Everybody else is still coming back from lunch, I guess.
Okay, thanks. I couldn't tell if people were off camera or not.
Mitch and I are sitting here, and the others are
Mitch is wolfing down his lunch.
on their way, I guess. We'll let you know when people come in.
Okay, thanks. And your dedication will be noted for the record.
Hey, Josh and Kaylee, did you guys say you had talked at some point about working on actually drafting some of the proposed language for the template sections? I think you said the two of you had been talking about that offline.
Yeah, we were thinking about maybe just starting a draft that could then be reviewed by everybody and give us something to at least work off of at the next meeting.
Yeah, I'd love to be part of that if you don't mind.
Yeah, absolutely. Well, I was kind of thinking we'd all, respectively be soliciting feedback from everybody, but we would just kind of gatekeep it to get it going. But absolutely.
Yeah, I wouldn't be mind being part of that initial part before we send it to everyone.
Yeah, you got it.
Awesome.
The argument tomorrow is at our Supreme Court building?
Mhm.
Okay, it's not virtual.
Hey, Josh, everybody's here.
Okay, great, thank you. We'll go ahead and come out of recess. Just a couple of things. I thought what would probably make sense, and of course we can talk about anything, but just structurally, we spent a lot of time on the evaluation criteria related to broad public records requests. But I thought we could spend some time on maybe a couple other components of the evaluation requirements in the bill. The exemptions to Chapter 239, and I know everybody's been provided that list that Matt Morris put together. And Matt, thank you for doing that. That was very handy. Maybe spend a little bit of time on some of the other criteria, such as the financial burden on requesters of public records, mechanisms to resolve disputes involving requests for public records, and methods for collecting and sharing data related to public records requests. And I thought maybe we could postpone a discussion on the fee schedules until our next meeting when we have the presentation on the fee schedules. But that was just my thought on how to be efficient with our time this afternoon. One other housekeeping matter is that I need to leave Carson City and go back to Reno for some commitments this afternoon. So I'm going to move to virtual, and I'm going to, because I'll be somewhat distracted, I'm going to have Vice Chair Work handle the chair duties for this afternoon. So hopefully that sounds good to everybody, and if so, I'll go ahead and hand over the gavel to Vice Chair Work.
Excellent. Well, that brings, was there any discussion on that? Sorry. Okay. All right. Starting then with the next issue on exemptions, we will open the floor to any comments, solutions, thoughts on that item. Again, thank you, Matt, for providing the document on that. I thought perhaps we could start the discussion with any exemptions that may require changes, maybe because they're outdated.
Can I request some clarification for the exemption list? I know we got one from Matt Christian. I don't remember. Matt Morris sent one?
No, it was
This is
Matt
Ben.
Christian.
I sent one. Sorry.
You sent one? I don't
sent
have
one.
that in my email.
Yeah, I sent one to the whole group, and then Matt, you responded to that with the one that you had.
Yeah,
Oh.
Ben had done a list, and then I sent the one that I had, but what I said in my email is that my list was quite old. You could tell from the first 4 or 5 listed statutes that my list was outdated, but it did have more of a reference to the specific statute that that went with this, with the title of the statute. Ben's had more, I think, just the chapter. So neither one was perfect, but we should have both of the lists.
And my apologies, I can't find that from one from Ben.
I'll shoot it to you.
Okay.
Yeah, I can.
And I might have just accidentally deleted it.
I can
but
resend
I
it.
looked my deleted items, it's not there either, so I don't.
Colleen McCarty for the record. Maybe I'm alone, but I haven't had a chance to really pour through that to see what's in it. Maybe we table this one until next meeting so we have a chance to look through it. Unless everyone else is better prepared than I am.
I agree, Colleen. Also, I wasn't aware that this was going to be discussed today, so it was not posted with the rest of the materials. I assumed that they were drafts, so apologize for the assumption, but it does sound like that may be better for our next meeting.
And Brittany, I just resent it.
Okay.
But I noticed as I was resending it that your email address looked weird. I hit a reply all to a previous email, and I think somehow your email address must have gotten corrupted. So while everybody else got it, I think you probably didn't.
Oh, good. I just wanted to make sure I didn't miss something. Thank you.
I don't know how. Yeah, I don't know what that was, but sorry about that.
Oh, no problem. Thank you.
Okay, I agree. Let's save the exemptions discussion to our next meeting, along with the standardized fee schedule. And any relevant information we'll make sure is posted in advance so that we can talk to those documents. Next that we had on the list was the financial burden on a person who requests a public record.
This has been, I think we've been discussing that throughout as we've been discussing fees in general and the extent to which fees imposed prohibit a lot of people from the opportunity to get records at all because they simply can't afford it. And even for those who can afford it, for instance, like our organization or other media organizations who make regular requests with tight budgets, there is an impact, even if an individual request is the sort of thing that there might be money for, they all add up. And I think I've heard a difference of opinion on what can be charged, but putting aside what can be charged and looking at what we want to recommend should be charged or confirm what can be charged or however you want to look at it. I do think that limiting it to the medium is the right thing to do because anything else simply becomes too burdensome for most requesters.
Colleen McCarty for the record. Just dovetailing with that, I think when we talk about an ombudsperson, the average person, public records requester, doesn't have the financial resources to pursue litigation. And so if the answer is no, and they feel as though they have a legal basis to obtain the records, most people don't have the tens, sometimes hundreds of thousands of dollars that it costs to bring a matter to the trial court and then potentially to the appellate courts. So I think that raises the value of an ombudsperson to avoid that litigation process and give the average requester and frankly the media requesters as well an opportunity to have a place to go when there's a dispute that doesn't require hiring a lawyer.
This is Matt Christian. I know we talked about this last time. I would just push back on that because, like I said before, it really shouldn't have to be that difficult to initiate a lawsuit. It could be a simple form like exists in other circumstances. I think I mentioned a motion for return of property that we see from pro se litigants on a regular basis. They have a form available at the courthouse for the person just to fill out. And then the example that I gave earlier about the gentleman who was unhappy about his mugshot being given to his ex-wife, his litigation against Metro is filed by him. He didn't seem to have any problem doing that at all. I think he did use AI, and he might have had to pay the filing fee, I'll give you that, but he didn't hire a lawyer. And he was able to serve us, and now we're obligated to respond. We did respond. We went to court, and maybe just as an aside, the judge in that case immediately sent us to a settlement judge from the senior judge department. And so that's free. There's no cost to anyone for using a senior judge to mediate a case. And we're scheduled to attend that mediation coming up. So just a kind of a counterexample. I understand a lot of people would want to hire a lawyer, but I really just don't think it's absolutely necessary.
Thanks for that perspective, Matt. Those are good examples. I think for the average person, there's an inherent power imbalance when you're a pro se litigant going up against seasoned public records attorneys, which is typically what would be involved when they're facing off with a government attorney in court and they don't have any legal background. Notwithstanding sort of the imbalance in expertise, there are required court hearings and filing fees and service fees and potentially document production fees. And it gets very expensive very quickly. And not only do people not have the money to do those kind of things, most people can't miss work in the middle of the day to go to court for whatever their largely personal public records matter is. So I think if we can find a way to create some sort of a different avenue for people to be able to sit down with a skilled mediator, arbitrator, ombudsperson, whatever you want to call it, it gives them an informal place to have someone else take an objective look at the dispute and try to find a resolution.
This is Brittany Walker. I wanted to offer just some food for thought, something to discuss. Most government actions have an administrative appeal process, whether it's a planning decision or a business license decision. For those types of decisions, there's usually an internal appeal process with the local government or the agency. And typically one has to exhaust, administrative remedies before pursuing a court action. One potential solution, I know a lot of local governments use hearing officers for, say, like a business license dispute. And hearing officers, aren't employees. They're usually, while they're appointed by the government, they are independent members of the community with certain criteria that they have to meet, experience levels, things like that. But they're a third party impartial, and the person can go before the hearing officer to appeal. Would there be any, what do you all think of an administrative process like that? I mean, it is common with any other type of decision, including ones that, affect substantial property rights.
Colleen McCarty for the record. I think we should be exploring all of these potential options because we all know that we're here because this issue is what started the ball rolling in the first place. And I think if we could figure out a way to make something work, even if it's not perfect from the get-go, we should do that. And I think that's what we keep hearing from the public commenters. They want this. The legislature clearly had a thought that this maybe was an idea. I just think when we began, no one had really taken a hard look at it. So I think we should be looking at all possible options and trying to figure out what this would look like, who would be the person, how would the person be appointed, how would we get it funded, all the things.
This is Leslie Nino Piro. I would absolutely be in favor of looking at some sort of administrative appeals process. Or if it's, we're all talking about the same thing, generally speaking, whether it's an ombuds office, public access counselor, administrative appeals process, whatever it is, it's a alternative dispute resolution process that would be an intermediary independent function before having to go to court. And hopefully that means both that pro se litigants would be able to, pro se aggrieved requesters would be able to do that without the assistance of an attorney. But just on a couple of things that we'll have to consider with that, I think the appointment process, who appoints, whether it's one person, multiple attorneys functioning in an office, are they technically within the legislative branch? Are they the executive or even judicial? Is this person or office governed by a commission, a board that includes elected officials, government experts, members of the public with public records background and experience, cost for whether or not to even use this process would cost anything for a requester. Off the top of my head, those are just some of the main thoughts that I have. Whether or not a decision by this adjudicator would be a binding decision, whether it would be persuasive on the next step and potentially having an appeal in front of a court. Does it turn it into a petition for judicial review versus a petition for writ of mandamus? So, the petition for judicial review would have some sort of deference to the ombudsperson or public access person, or the current process, I think, is just the district court is reviewing de novo. So those are just some of the things that when we're having the discussion about an alternative dispute resolution solution, we should keep in mind.
I think that's a good segue to the next issue item, which is the mechanisms to resolve disputes involving requests for public records, including without limitation, mediation, and other types of alternative dispute resolution. Before I put some of my notes in that section too. Was there anything else on the financial burden of a person who requests a public record? Okay, now let's continue to the discussion.
This is Stacey Lambert for the record. Oh,
please.
Sorry. I just wanted to point out, I really think it was a good point made. I can't remember who made it. I remember hearing it though, that, not every taxpayer is using the service. And it is an extra service being requested because, we have almost everything online now for people other than, maybe, our sheriff's office and things like that. But I really think it's important to look at are our voters and our taxpayers willing to pay higher taxes? Are they willing to pay to make sure that, this office is supported? I'm very nervous about adding additional costs to our taxpayers when it could be done on a service basis. You want this service, here it is. If it's online, we can direct them to it online. They can get it for free. But if they want us to package it, send it to them, whatever, then I believe there should be charges. But that's just my take on it. And I totally agree. And I think it's important to look at that as a service. I really do, because a lot of people use those public records requests to make income for themselves. That's just my thoughts.
This is Mitch Fox for the record. Thank you for those comments. I happen to believe that public records transparency is an essential form of government. And I think the argument was made earlier that people prioritize different offices and different departments differently. So, you know, I've never taken a bus system, but I know my taxpayer dollars go to pay for the bus system, and I've never had a building permit pulled, but I know and we go down the line. I mean, there's lots of examples where our dollars go to agencies within local government and state government, but we're not a direct recipient or a beneficiary of that. So I don't really kind of buy into that argument. I just happen to think that this is a priority. It may be not the most important priority, but I think transparency should be a transparent. I think everybody on this committee actually believes that. Thank you.
Great, thank you. Anything else before we continue the discussion on dispute resolution?
One quick comment. This is Leslie Nino Piro. I know we're all still evaluating in other states what some of their solutions and some of their practices are. And from my preliminary research, the vast majority of jurisdictions in the US allow at least some limited billing for personnel time once a grace threshold is passed. So commonly it's the first 30 to 60 minutes. We've talked about several hours, 5 to 10 hours, but just as a threshold matter, we can see that many jurisdictions throughout the US explicitly allow for billing time, even if it's just in limited circumstances or after a grace threshold is passed.
This is Brittany Walker. I just want to, without getting too far into fees, you know, I think the point is well taken that records should be available to the public, but for all government services, whether it's a bus ride or building permit, a reasonable fee is typically assessed. And I think it would be reasonable to at least have a baseline fee for even just a records request. It doesn't have to be very much. It could be nominal, but it would help because there's some things that people request that they don't really want and they don't really have a purpose for. I mean, we've had records requests that we spent lots of time putting together and they don't pick it up. So just having like an upfront fee, even if it's like $1, well, I think would help deter some requests that requesters, you know, really don't need. You know, even if it is a government service, it'd be heavily subsidized because it'll take the staff more than $1's time to get the record, but enough to just deter unnecessary requests.
Okay, thank you. Anything else before we move on? Okay, we've had some discussion already on the resolution to disputes involving requests for public records. Do we have more conversation we want to have here?
This is Brittany Walker. I think this is an opportunity to discuss some options, you know. I mean, we're supposed to be evaluating and discussing this now. I mean, I think we know there is no real existing process, right? So we can report that out. We could talk about use of mediation. I'd like to have people discuss the idea of an administrative process within each government agency. Like I said, it's a common practice for all local governments, all agencies to have an administrative appeal process for a decision they make. So I think it fits right into just principles of democracy to have that due process level at the local government level first. Is it as an option if we could discuss that, or if it should be a state agency, but you know, that will come with a fiscal impact to the state. So just things to consider, but I think it'd be helpful to talk about it now.
Colleen McCarty for the record. Maybe it would make sense for two people on the committee to sort of take this on and try to come up with a plan that, or a couple of different options. And then we have something more granular to look at rather than sort of bouncing back and forth when nobody's taken a hard look at it at the moment, unless you have a clear idea already.
Well, if you appoint a subcommittee, open meeting law still applies. So we'd still have to do notice and all that. So if we did do a subcommittee of two, it even says two or more persons. So that presents additional challenges for the time, but I don't see why we wouldn't all be qualified to talk about broad principles of what you'd like to see in a dispute resolution process. I mean, of course, we could look at other states and see what they do. But I mean, is there a strong, it shouldn't be an administrative process. Like, don't you think we know enough to at least have an initial gut reaction on that idea?
Yeah, I guess I don't understand what you mean by administrative process exactly. Who would be the administrative body? Who would be the decider? So I'm like, the devil's in the details, right? So if you can maybe speak more about what you think exactly that would look like, great. Let's talk about it.
Yeah, there's lots of ways we could do it. One example I mentioned is like a hearing officer. So decision says, this record is confidential because of X. Then they appeal to a hearing officer. It has to get assigned. The hearing officers would be appointed by the city council, maybe, or other governing body. And they'd have to meet certain criteria, have experience in either just experience with public records law, something like that. They could be local attorneys, just similar to how a business license appeal is done. So typical with a business license appeal, we don't follow this process, but Boulder cities, our processes are a little bit archaic, but like Henderson or some of the larger jurisdictions, they all have hearing officers, and the hearing officer is appointed and is just a member of the community. They're sometimes retired attorneys, and they get a fee for each case. And then it's similar to like any administrative appeal. So you go, the appellant has an opportunity to make a case. The hearing officer is bound to look at the record before them. So just the request, basically the response, and of course, knowledge of the law. And the appellant would go first. Hearing officer listens to that, then listens to the government side, and then makes a decision. And then that is appealable under a petition for judicial review under NRS 233B. And you would, similar to you're kind of already doing with the writ of mandamus now. So it'd just be a petition for judicial review instead of a writ of mandamus. And so but just having that initial level, and it wouldn't cost the appellant anything, right? They would just have that ability to seek an impartial third party, and that person could overrule the government entity.
This is Matt Christian. I mean, in theory, that sounds like a great idea. I think the only thing that would slow that down is paying for the hearing master. So if there was a large volume of appeals, and the requester / appellant didn't have any skin in the game, to, lack of a better way to phrase that, there could be a very overwhelming number of appeals. And then if the agency were the one paying for the hearing master, that could end up being a kind of a significant expense. So I think that would be the only thing I think that would be problematic. And if there were too many, then maybe there would be a lack of hearing masters.
Yeah, those would be challenges. Yeah. And sometimes it would be probably challenging to find a hearing officer with public records experience.
But with that said, I'm wondering if anyone else has any thoughts on a hearing master concept.
This has been generally on the concept. I would say that we would want to make sure that it's constructed in a way that one, the person is, whoever the decision maker or decision makers is or are independent. I'd be concerned if they're appointed by the governmental entity, for those governmental entities who are looking to keep records confidential, that they may skew the choice. So I think the process would have to be one where everyone could be comfortable that this was an independent person. Two, that it not be constructed in any way that in the end it can just be used to delay things rather than expedite them, as well as ensure that, and this maybe goes to what Matt was saying, but on the other side, that it doesn't in any way increase the costs. I mean, I think the idea should be that this would speed things up and decrease costs, and we would need to make sure that the structure is such that it couldn't be used for the opposite effect.
Would just a requirement in the law that the hearing master shall be neutral, would that be sufficient, or what other suggestions would you have to ensure that the public agency wasn't just going to hire hearing masters that were going to rule in their favor?
I haven't thought through the details of how it would work. I don't have a particular proposal yet. I'm happy to think about it, of how to appoint them, but I think the key would be ensuring they're appointed by a system that doesn't give the governmental entity the power to, in a sense, choose who it's going to be, or limits the pool they can choose from in a way that ensures, neutrality and a commitment to the public records law itself rather than to the entity that they're working with, as well as protect them from any sort of retaliation, firing basically for decisions that anyone doesn't happen to like. Again, this is more just flagging issues, I know, than providing answers to the question. But, just in the spirit of talking it through, at least generally at the front end, and then coming up with ways to achieve the goal, but really just flagging concerns at this point.
Brittany,
Mitch Fox here. Oh, sorry.
Go ahead, Mitch.
Brittany, was your proposal each jurisdiction or each municipality would have their own hearing officer? And the reason I brought that up is I kind of wanted to revisit the idea of an ombudsman office, which would be cross-jurisdictional. It would sort of ascertain some consistency between jurisdictions. For the general public, sometimes it's confusing because each government handles it differently. So I guess that'd be my question. Would your proposal be just a hearing officer for every city and county and state?
Yeah, that was my idea. And I'm not opposed to an ombudsman either, but I think the challenge that they had at the legislature was finding the funding for it. And so this way it would be just an administrative process with each local government that they'd have. And that way, at least the person is getting a due process, right? It's not just, oh, this person denied my request and I have no other recourse, right? There's this appeal process. And, respectfully, I do disagree about the appointees being controlled by the government just because they're appointed by the government. I think there's lots of situations, especially if you use the hearing officer model, where the hearing officers don't just side with the government. They are objective and look at both sides. I like in the presenter we had today, Ms. Singh, she talked about her confidence being restored, even though the governor was appointing, because the person was appointed to a term and could only be removed for cause. So we could do something like that so that the government can't fire hearing officers who aren't siding with them or something like that. I think there's safeguards you could put in place to help encourage impartiality while still having it, because I just don't see, and it's not that I'm opposed to having an independent person. It's just that I don't see how you do that without, I just don't see how you could really do that. Because the government, if you want it to be both free to the requester and then how do you not have the government appoint and pay for it? I mean, if you did mediation and did an impartial mediator, but mediators aren't going to do this for free. And so
if I could answer that, Mitch
yeah.
Fox, for the record, in my research, there's 19 states that have this kind of system in place. Some of them have the legislature itself appoint the person rather than the AG, the governor, or so there could be that the appearance of political bias if you invested into that body itself. I think that's more feasible, at least from my standpoint.
Yeah, and again, I have no objection to a process like that. I just think part of the barriers last time was funding.
For sure.
I would, Colleen McCarty for the record, I would be in favor of either private mediator and there's some sort of a budget for that. The Supreme Court in our state, every appeal you file, you automatically get funneled to a settlement judge and that's free for the parties. And I don't think those people, I don't think it's a significant fee that they charge for that service. So maybe in lieu of creating an office with multiple staffers and an ombudsperson, maybe it makes more sense to create some sort of a program like that you could potentially tap into, and there's funding for those people or that person, or maybe it's a pool of people. Or the other option would be, like Mitch noted, like a legislative approval or someone from the judiciary, the judicial branch, that I think takes it out of the, even just by appearance, it's a ombudsperson that's been appointed by the government that may be seeking to withhold records. So I think the independence is going to be key. I agree that one office is preferable just for consistency of decision. I think this person has the potential to drive policy. I love the idea of that person also being someone who does training and helps with those manual updates that we've heard about. So those are just some of my thoughts.
This is Leslie Nino Puro. So with just one note and thought on, I agree that the courts do have the mediation programs that are set up, but they also have the filing fees that we've talked about before. Although there is a process in place for litigants to request informa pauperis status, so at least and perhaps we could look at some sort of process built into any administrative appeals process, but at least there is some sort of funding mechanism there when a person files a case, at least on an initial facial basis, they would be paying a filing fee that I would imagine goes towards mediation programs as well. Another potential model to think about, I think we've heard folks talk today about Connecticut that has some sort of a commission. Even our own body here, the appointment process was pretty wide and spread around different elected officials. So that's something to think about. Also, the Nevada Commission, the Ethics Commission, has appointments from both political parties, and it's a random draw and starts with a panel of three members of the commission. and then may proceed to a full commission. So I do think that there's models around the state even that we could look at, but they're all going to cost a little bit of money. They just are, and I'd love to hear more suggestions about where do we suggest to the legislature that they get the money.
Colleen McCarty for the record. Brittany, you mentioned that funding was a barrier last time. Do you have more information about that? Because I didn't understand that they even started looking at funding, but did they? And I just missed it.
Well, legislature is not subject to open meeting law. I think a lot of things they decide there's no record of, but from my recollection, I wasn't up there, but there was a fiscal note on the bill because of the cost of creating an ombudsman, and part of their ideas, this is all secondhand, I heard, was that let's create a task force to really look at the issue and see what they need before recommending before trying to create like an office, because of it was an expensive. I mean, creating an ombudsman, you're going to have to pay for staff, especially all of the duties that they have. So I mean, that would probably be multiple positions. And so creating a whole new state agency would be extremely expensive. So my understanding was they thought that funding was an aspect of it. But there's no record of that. I don't know if that was in the legislative history. There's a lot of things, like I said, they get decided with leadership and they just change things and bring back a compromise.
Okay, because I was loosely involved with that, and my understanding was because there wasn't broad support for the idea, that's what eventually came to the creation of this committee. So I'm just curious if there was a fiscal note and I just don't know, and that was an issue. Does anyone know beyond just?
Well, guessing? I mean, that was my understanding. I can look to see if there was a fiscal note, but I think it's true that would have a tremendous fiscal impact, like regardless,
No, I guess I'm just wondering if they had come up with a number already, if we knew what that was.
I can look, and I'll look while we're talking and see if there's a fiscal note on there. We could probably keep discussing while I look this up.
This is Kaylee Work. I think Ben said something important earlier about time, in ensuring that this process resolves some of the time delays and not extends some of the requester time, the length of time. And I don't know how that gets built into this process, but I think it's, I'll think about it. But I think at some point, if records have been not provided over an extended amount of time, we should consider, at what point does this third-party mediator, step in solely to ensure that the process continues.
This is Matt Christian. I'm very supportive of an overall statewide ombudsman. I think that's theoretically a great idea. It would be especially effective is if the ombudsman would publish his or her decisions, or if it's a panel of ombudsmen, to make those available, because then a body of law will develop more quickly and provide more clarity to us over time. I think that would be very beneficial and helpful. I think there are two major issues with it, and I just don't think it's realistic, because I don't think that it'll be funded. There is, I think well-publicized, we all know that the state is faced with budget crisis. it's like we talked about earlier, if there's going to be a creation of a new office, money will have to be taken from somewhere in order to fund this office. I think the other problem would be that if it's underfunded and say there's only one ombudsman and one staff member, the person will quickly become overwhelmed and the resolution will be delayed. Who knows how long it'll take to get a decision from that person. So if it's very well funded, I think it's a great idea. But otherwise I don't know that it's realistic, and I don't think it won't save any time, because the ombudsman won't make a decision instantly. They'll have to have both sides being heard. There'll have to be a time scheduled to hear the matter. Maybe lawyers would file briefs, and it would just take some time. So the better funded it was, maybe the quicker it would be. But again, I think that kind of comes back just to being realistic, and whether or not the legislature would actually fund such an office, I think is questionable. But I would be happy to agree to suggest it to them. I just don't know that we'd be fulfilling our purpose if we only suggested that one option, because I just don't know that it has that good of a chance of actually happening. I would go back to kind of where we're at. The system we have right now is pretty inexpensive. It merely requires the filing of a lawsuit. Judges are free, other than the filing fee, which could be waived. There really is no cost. And I know, at least here in Clark County, if you file a motion or a petition for a writ of mandamus, judges are going to set a hearing within a relatively short amount of time, 30 days, 45 days. You could theoretically get a final decision from a neutral person. We would all agree that an elected district court judge can't get many more unbiased than that person. The taxpayers are already paying for that person. The system is kind of already in place, other than the cost of the filing fee in district court. So those are kind of my thoughts on it. I'm in favor. We could outline all 4 or 5 or 6 of these suggestions. I think they're all good ideas, but all of them cost money, other than the litigation route.
Mitch Fox, for the record, I can't put myself in the category of being in favor of more litigation. I like what Leslie brought up about the Nevada Commission on Ethics in terms of funding. Most of that comes from special assessments on local governments, and it's not the state government. So 3/4 of that doesn't impact the state budget at all, and they have a minimal budget. So perhaps we can look at a funding model that replicates what they've done successfully. I wouldn't want to throw that idea out automatically by saying it'll never get funded or there's just no funding for it. Again, I'm not delusional. It's definitely disadvantaged by having a fiscal note, but I don't think we should cast it aside just because of that.
I just wanted to let you all know, I did look it up. I don't see a fiscal note on the bill, but I do believe that was why. I mean, this would have created there would have had to be a fiscal note, because this created a new office within the executive branch. So even though they never submitted one, there's no way it would have been able to pass without funding. So, because the bill does say fiscal impact on the state, yes. So maybe they didn't put a number to it yet, but any bill that says that has to go to the money committees. I've worked 4 legislative sessions and know that well. So, yeah.
Colleen McCarty for the record. I think if the court system were working, we wouldn't be here. So I'm not sure that continuing to rely on the system that's in place is providing the sort of review that the legislature asked us to do here. So I appreciate Matt's perspective on this, and he spends a lot of time in court, probably more than any of us on these issues. But I think court is a barrier to most people.
This is Leslie Nino Puro. Just to give a little bit of perspective, I've looked thus far at the Office of the Oregon Public Advocate, which the public records advocate there does many of the things that we've talked about in terms of providing an educational perspective for the public to help guide how they craft records requests. Also provides training to government agencies and does the mediation functions, which we've discussed. Some of the reports and budget requests that I've been able to find online from their office and getting it off the ground relatively recently, only in the last 6 years or so, they ran into problems with not having enough funding in the beginning and having delayed resolution of requests for mediation. And then also even just in the 2023 to 2025 budget, 2 full-time employees, and I believe those were full-time attorneys, was at a cost of $895,000. So just a little bit of perspective on how much we're talking about in running an office where they do the things that we're hoping to accomplish.
And just to clarify, I just wanted to throw out a question. If we do have or determine that we want to make a recommendation for a third-party intermediary, do you see that as optional or a required task before litigation?
This has been, I think, the only way to avoid it being simply an additional hurdle and time delay is that it's optional for the requester.
This is Stacy for the record. One thing that we could look at too for offering how to fund it is through charging for public record services. So the charge to the people for those records could fund this mediation program. I think they have a model of it in the foreclosure mediation now, where they pay a set fee for any time they need to request something, and then that fee gets held to support that department for the mediation of the foreclosures. Just a thought.
This is Brittany Walker. I think that's a good idea. And even if there was a nominal fee for each record request, like again, like $1, that money could be funneled toward the mediation program. And I'm sure across the state, we charge $1 for every records request. That would probably be a pretty good amount of revenue to fund a program like this.
Again, this has been, I understand we have to figure out funding for this, but I think it's counterproductive if that funding turns out to be something that simply increases the cost of public records to those seeking them.
Okay, well, I think we have a few ideas on the table. I think there's still a lot of details to discuss. It seems like we have some things to work with, though, for our next iteration of the draft report. Do you guys feel like we should pause on this topic here and move on to the next, or do we have more to add?
I think we're good moving on down here.
I think that was a great discussion. Okay, the next item we have was methods for collecting and sharing data related to requests for public records.
This is Leslie Nino Pirro. I will kick us off by saying, I think data is very powerful. When we start to understand exactly how many requests we're talking about, the potential staff time that is used by every agency, there's some different metrics that if we collect that information and we aggregate it into some sort of report, that could help move the needle for the legislature and to craft funding mechanisms that would be most equitable for all state agencies, municipalities, counties. So I think it's a matter, and this is the same has been true across other parts of Nevada law where the state was not collecting information. And in recent years, I think the one example that comes to mind is sentencing data that is now collected. And so I think it would be great for us to have a suggestion of just basic data. It doesn't have to be anything too complex, even if it was just the number of requests, and some amount of staff and estimates for how many folks are working on public records requests within an agency, and the time that is spent on that, and whether or not fees are being charged, and types of, as soon as I stop, I think of another one, and types of software solutions that are used to assist with public records requests, and how much does that cost?
This has been, and just to keep your list going, how long the requests take to, how long between the request and the response, and the extent to which the responses are denied, whether they're, I mean, I don't know how detailed we get, more detailed the better, I guess, but also the more difficult it is. But, with granted in part, denied altogether, or what. Even if we could, what sort of subjects are subject to denial or provision. I mean, I certainly agree. All that information would be great to have if somebody could collect it.
Colleen McCarty for the record. I'd like to add to the list too. I'd like to know how many dedicated staffers each entity has for public records. I'd also like to know how much revenue each entity brings in annually for public records requests. Those are my two. And then with regard to this category, I really have been thinking about the idea of creating some sort of a technology committee that maybe meets in the next interim between sessions, because there's only so much we're going to be able to get through. But technology is exploding right now, and it seems like a lot of government entities are, as we know in our state, are way behind. And there are a lot of potential efficiencies, I think, that could be gleaned from various types of software programs that can, scan for certain information, that can redact certain information. And there may also be opportunities to gain favorable pricing on these kinds of things if it were to be sort of a broad-based government purchase. I don't know enough about it, but to have some of the IT folks at various entities collaborating with some of the public records staff and maybe some members of the public and journalists in a way, the thing is, we're talking about, you know, if I'm entity X and I have no searchable database on my website, where do I even begin? And can we create efficiencies in that regard? Just some of these kinds of things to keep moving the ball forward.
This is Stacy Lundberg. I just wanted to clarify one thing. It's like the public records request does not generate revenue. We cannot look at the small amount that we've charged, you know, people for these massive requests versus the staff time and stuff. So I think, you know, to ask for what revenue was generated, because the law only requires what the actual cost if we charge at all. So, I mean, in our county, we very rarely charge, just out of the SO sometimes because of the time and the reduction periods, but there is no revenue generated by public records request. It is a huge expense to the counties, and maybe we should look at that expense alongside of what it actually is costing the overall taxpayer to provide that information.
Colleen McCarty, for the record, that was probably a poor choice of words. What I'm getting at is just how much money is taken in by the government entity for public records requests.
Okay. Any other questions, commentary on item 11?
Yeah, Colleen McCarty again for the record, and maybe one of you can help understand, but how does an agency, why is there, maybe a better way, why is there such disparity among different agencies with regard to what's publicly available on a website and what is not? Is that a function of sort of the will of whoever is running that agency? Does anybody know, like, why do we have some that have all this information and others that have none? Does anybody know?
I think probably maybe for some of the rural local governments, you know, to have, like, we use Laserfish to put all of our records online, and it does cost money, you know, so it could be just cost of having it in the available online. I'm just speculating. I think some agencies, most of their records, you know, like, for example, Metro, like, all of their records are criminal investigations and things like that wouldn't make sense to post online. So, you know, other agencies too might have things that the bulk of their records aren't not that they're not public, but it's you know, I mean, I don't know, it just can be tricky to have that available to anyone because some people can use records for nefarious things, right? So there should be some controls. I mean, we do post, and I think a lot of the other local governments and larger local governments in Southern Nevada have available anything that goes to a council agenda. Like, I know I could search Las Vegas, Clark County, North Las Vegas, anything that's gone on their agenda, I could keyword search it, pull it up. I have found full contracts and anything on there.
And-
This is Matt. I mean, I don't know, can you be more
Yeah,
specific?
I guess what I'm trying to get at is it just that whoever is leading that office decides I'm making a decision that I'm going to ask for this budget line item and I want to do X with respect to my website? Is that why that happens? Or is it like, I'm just trying to, like, what is the catalyst that gets things more updated? I honestly don't know, so I'm asking. Do you guys know?
Leslie Nino Puro, I can just anecdotally and not in any official way, but what I've seen is it's all resources, it's all budgets, so many different competing resources. It's staffing. Do you have the type of IT staffing that it takes to make sure that this is it's a lot more labor intensive than I think folks realize. And, many times we are waiting for, there's a central, as folks learned during the state cyber attack last year, that there's a centralized technology office in the state that sets policy, helps with approving different types of software that we are allowed to use on our systems so that we stay safe. So it's just it's really nuanced, I think, throughout state agencies, and depends on the types of data and records that they hold. For instance, I know that medical records with the Department of Corrections are still handwritten. I know it drives people nuts. I mean, as attorneys, we sure don't like it either. We would love that information to be digitized or stored digitally. It would make all of our jobs easier. So it's investing in infrastructure. I seriously doubt that it is just, a decision from on high decision makers that we don't care if we have more up-to-date websites and systems. It's just the limited resource. I rail on that all the time. Limited resources to go around. And so we do the best with the money that we have and the staffing that we have and make tough decisions that way.
Yeah, I mean, from my perspective, I would just be curious if there was a specific example. So for instance, if the Reno Police Department or the Henderson Police Department were posting something that Metro was not posting, then I would be happy to hear about that, because maybe it is a good idea. Maybe we would post that in the future. Maybe we just are not aware that people are interested in that kind of information. I mean, we have so many different programs. I know, for instance, right now we have a whole webpage devoted to drones. Drones are in the news. Everybody's interested in drones. They're doing a lot of good police work, these drones, and the operators of the drones. But there's also privacy concerns with drones. So in order to kind of fully inform the public, someone at Metro, probably the sheriff, made a decision that we should get in front of that, let everyone know this is what we're doing. But there probably isn't a webpage devoted to, how do you conduct a robbery investigation? Because that's old news. There wouldn't be as much interest in that. But like I said, I'd just be curious to know if any other similar agencies are posting things. We have a whole website that's based on GIS that tracks current crimes. So anyone can go on that website and it's a tool. You can use it to look at crimes in your neighborhood, what types of crimes. It just doesn't tell you who the criminals are or who the victims are, but it tells you, and I don't think it gives you addresses either. It gives you cross streets and the blocks. So I don't know how much people use that, but, and I don't know how we made the decision to spend the effort on that, other than just trying to be transparent. But, good question. I think any agency would be open to the idea of posting more, especially if it was a specific suggestion.
It might just not be the demand for it too. I've noticed in Boulder City, we have a very engaged community, and our community cares about everything we're doing. And so we are just going to put it online so you know what we're doing, because our community cares so much and is super involved. But other communities don't have as an engaged public. I think we have more public comment than Clark County or North Las Vegas has at our meetings, honestly. So it could just not be the demand for it.
I'm just thinking as a way to reduce the number of public records requests that you all have to field, right? If this stuff is already out there, and a lot of it's out there, you're going to get fewer requests because people can find it on their own.
Yeah, I don't think the amount of requests we're getting is what the problem is. It's the overbroad requests and the requests for information that are vague. And so I don't think it's the volume necessarily of requests, because like I said, if it's just a contract they want or, you know, a specific record, that's pretty simple. But if they want information or subsets of data that we have to organize, you know, all or any communications, or those are the types of ones that are really time consuming.
Excellent. All right, we did discuss moving the standardized fee schedule and the exemption conversation to the next time we meet. Any other discussion on item 11? Okay, let's move to agenda item 12, consideration of topics and next meeting dates and related issues.
This is Leslie Nino Puro. We had discussed September 10th as our next potential meeting date. I have to first say thank you to the Legislative Council Bureau's folks who are providing this space and the technological resources for our task force to meet. I would ask, amongst our group, there's a couple of people who are going to be out of town on the 10th of September. So I'm hoping that maybe there's availability for either September 21st or days in the week after that. So that would be the week of September 28th. And I have looked into whether the meeting rooms here are available. They are. Any day that week of September 28th and also September 21st.
This has been, as I mentioned, the 21st. I'll be out of town traveling. The week of the 28th works for me.
This is Matt Christian. The 28th is good for me. Until Wednesday. There's a public lawyers state bar convention starts on Wednesday, the 30th. But Monday, the 28th and the Tuesday, the 29th are good for me.
Brittany Walker, those are both good for me as well.
Kaylee Work.
Mitch Fox here. Sorry.
Those dates are good for me as well, and I believe those dates are good for the chair as well.
Mitch Fox here. The 28th is not a good date, but the 29th is.
Colleen McCarty, the 21st is not good, but I could do the 28th or the 29th.
Looks like we have a winner.
It appears the 29th is the winner. Okay. I will do my best to finalize that and circulate that as quickly as I can. Do we want to, I don't think we had looked at another date in October. Do do we want to think about that right now, or we want to wait until the 29th?
It'd probably be a good idea to get a tentative date for October, and then we can confirm with the chair. And I think he's the only one we lost right now, right? Or is he, he was able to join virtually?
Yes, thank you, Brittany. I believe he is listening. I don't know if he has access to get off mute at this time. But I think that's a good idea, Leslie, if we can shoot for maybe the week of the 12th in October. That'll give us enough time, 2 weeks after the September 28th meeting, and enough time to maybe squeeze in one more meeting if we need to.
This is Matt Christian. The week of October 12th is the 1 week that I'll be out.
I believe the September meeting's the 29th, right? September 29th?
Yes. Yeah. Thank you.
Okay.
What about Monday, the 19th of October?
That works for me.
That works for me.
I'm available.
Works for me.
This is Josh. I'm on now, and that works for me too.
Me too.
This is Stacy Lindbergh, and that's the start of early voting the next 2 weeks for me. So it's hit and miss, but if I can make it, I will be there. If not, I will send a note to the chair to excuse me.
This is Mitch Fox. 19th works. This is Mitch Fox. 19th works. I might have to leave early around 3 o'clock if we go this long again.
I'll talk fast.
Excellent. So I can confirm September 29th and October 19th for our next 2 meeting dates. Following up on September 29th, our next public task force meeting, were we going to move the presentations from today to the 29th of September that couldn't be here today?
This is Matt Christian. I can try to see if John Abel is available on the 29th for his presentation.
Okay, thank you.
This is Colleen McCarty. The ACLU plans to present at that meeting as well.
Okay, thank you. And then Colleen, do you have those 2 topics? Do you plan to present on those 2 at the next meeting?
Yes, thank you.
Thank you. Okay, so we have 4 presentations lined up for September 29th.
Could I ask a question about the Northern Nevada Law Enforcement Agency topic? What's the purpose on that?
I just want to use it as sort of an example of what a lot of people experience when they make public records requests. So I want to have that in the record and talk a little bit about what occurred there. It won't take long.
Can we invite the Reno folks to comment, or are you going to elicit their response, or?
Their responses are in the record and they've been attached already. If you want to invite them to explain why a simple request took so much time, then that's fine. But I mean, their responses are articulated throughout the communications.
Well, I'm just curious. I mean, we can always talk about our personal experiences with this, and it just seems, I mean, I think the legislature tasked us with making these evaluations and recommendations. Is it really productive to like call out specific agencies and talk about, like, I mean, you can talk about your experience with that, like, at any agenda, you know? So I don't know if does it warrant its own agenda item that we have to have?
I think I agendized it just so it was clear to everybody what was happening. And you all spent a great deal of time today talking about the concerns of your agencies with regard to public records. The experience that I had is the experience that I hear from public records requesters all the time, including my own clients. And it's just an opportunity to be able to sort of clearly delineate what occurred each step of the way, so it's in the record. And what I experienced is very common, unfortunately. And while I certainly didn't make these requests with the intention to bring them here, I was so shocked by the responses I was receiving that I think it's worth having it put into the record.
Yeah, and I'm just saying we were all appointed to talk about from our personal experiences. So I just didn't know if it needed to be an agenda item or if we could just talk about our experiences generally with regard to the recommendations and evaluations we're making, right? That's all I was pointing out, is just like today, we spoke from our experience. You could speak from your experience. I mean, I just didn't know if it needed to be like a specific item.
Well, I think since there's documentation that went along throughout the process, I want the documentation in the record, and I want to be able to talk about what the documentation was so that the folks who go back later and look at all of this, it's in the record and it's clear.
Okay. It just seems like this was really more a solutions-oriented organization rather than a like, let's go live through the past or call out specific people. Anyway, I just was pointing out that we can always talk about our personal experiences. That's part of why we're on this committee. So I just wanted to point that out.
Yeah, and it's not about calling anyone out. It's about putting into the record what people are experiencing on a regular basis. And I think that it would be helpful for the committee to see what these responses look like, what sorts of arguments are being made for why records can't be released. So I do believe it's part of the discussion.
This is Stacy for the record. I think it would be important to hear both sides. I would like to hear if we're going to talk about specific departments, I would like to hear the department's reasoning or answers. Even, it may be documented on your site or whatever, but there might be underlying things that couldn't be released or something that they could clarify for the board during that time if we're going to move forward in that way. Just my thoughts.
Yeah, and I mean, and we're just not, that's not our purpose. We're not here to adjudicate like who's, I agreed. I'd also like to hear both sides so that we have in the record like a full picture, but that's also just not our purpose. Like our purpose is to, hey, these are issues, and if this is what you've experienced and this is what you feel is happening across the state, then hey, these are the issues that are happening and what we need to address. I just don't know that it needs to be so like its own agenda item, and we can just look at it with, a forward facing view about like what needs to be changed in order to address the scenario you experience, rather than being this sort of like, we're not a adjudicative body. We're not saying so-and-so's wrong and so-and-so's right. We're just trying to find solutions of public records law that solve your problems and solve our problems.
This has been, it seemed like all morning we heard a number of specific instances of public records disputes or instances and issues that a number of people on the panel were explaining. And of course, the other side wasn't here, and people on the panel were using it to advocate for, certain types of changes that they thought were necessary. I don't see how this is any different, and certainly would be appropriate.
Well, I'm just saying it wasn't its own agenda item. It was speaking from our personal experience in the context of making these evaluations and recommendations. So that's all I'm saying is I'm not saying you can't talk about what you experienced. I'm just saying I don't know that it needs to be its own agenda item.
Well,
that's all I was pointing out.
It was placed on the agenda for this meeting, and due to some of the issues with the fee schedule, I asked that it all be moved to the next meeting. I do think it's appropriate. I want to be able to make this presentation, and I don't know why we wouldn't, frankly.
Yeah, I'm not going to stop you. Oh, go ahead.
This is Leslie Nino Puro. I think we've all had a great exchange of ideas today. The difference that I would point out is that I think each one of us, I cannot remember any one of us calling out a requester specifically, and saying this person is a vexatious requester. This person routinely submits overbroad requests. We were careful to give examples from our personal experience, but without naming those people specifically. And so I think that we can do that and speak from experience without it, especially when if you don't have an intention of even inviting that agency to be here and provide their thoughts and comments.
I think we have heard throughout this process various agencies that were responding appropriately to public records and various agencies that were not. It was included in the presentation by Dave Ma. I'm moving forward with it, and I don't see a reason not to. And if y'all don't want to listen to it, I guess you don't have to, but it has clear documentation of a request from beginning to end, which is not something that we have had presented in our forum at this point. If you want to invite the various entities, please be my guest. I would love to hear what their thoughts are, but their thoughts are very clearly articulated in all of the communications because they're required to articulate them under the statute. And I think we have listened very patiently to all of your comments today from the government side of the house about overbroad requests and everything else. And this is something that hasn't been presented yet. And I think it should be in the record.
Yeah, again, I don't think anyone was saying you can't talk about your personal experience or talk about this issue. I was just pointing out, we've all talked about it in the context of what the purpose of we've been tasked with evaluating by statute, and we didn't have it as our own agenda item. And that's all I was pointing out. No one is saying you can't talk about what you experience.
Well, it really feels like I'm being silenced here, and it's not, I don't think it's appropriate. I think what I'm bringing forth with respect to both the fee schedule and what public records requests and responses look like is very germane to what we're talking about.
Can we move on? I would support having as much information as possible. I think from the sake of balance, whether you want to call it a personal anecdote or an agenda item, I think it's semantics. I mean, Colleen has already said that it's not going to take all that much time. Time is of the essence. And I think the information that would be brought to bear, which was already on the agenda, should be brought forward. I think we're stuck on this, and I don't think it's that big a deal.
I'm not stuck on anything. I feel that I'm being accused of trying to silence someone or say they can't talk about something. And I was just saying procedurally, we can talk about it without it being called out on the agenda is all I was saying. I welcome you to talk about it. I at no point said we can't talk about this. And so I'm not silencing you. Like, it's ludicrous.
Okay. Kaylee, work for the record. I say we move on. We do have the next meeting dates. We have the topics for our next discussion. If there is no other related issues, I'd like to move to item 13 and open up public comment. Before I do, was there any last final words on item 12? Okay, seeing none, we're going to open it up to public comment. We're going to start here in the room. We don't have anyone here in Carson City. Moving to Las Vegas. If you
There's
have public
nobody here in
comment.
the room.
Okay,
There's
thank
nobody
you.
here in the room.
Thank you. Anyone online wishing to go on public comment, please unmute yourself, state your name for the record, and you have 3 minutes.
If you would like to provide public comment, please press *9 now to take your place in the queue. Again, if you would like to provide public comment, please press *9 now.
Hello, once again, my name is Kathleen White. I'm here in Henderson, Nevada. I'm just now facing a motion that I received to dismiss my public records case against the Attorney General's office. Having listened to them whine about costs and how much work it is for them, I find it lazy and laughable. Given the time and care is taken to obfuscate the record, I've seen my name spelled 5 different ways, descriptions of, quote, that new guy whose name I don't remember, or the colleague on administrative leave, or that person they had a conversation about. We have to guess as to how you have referred to that name or person you're trying to get the records on. I've reached the point where I'm ready to let it go. I'm never going to force the hand of this administration to release records from a case that was effectively closed before it even began. When I first filed my lawsuit, I asked my father to review the Nevada Public Records Act. He's an attorney admitted in Maryland and the District of Columbia. He spent more than 40 years as a regulator with the FDIC, overseeing banking shutdowns during the crises like the savings and loans collapse in 1987 and the 2008 financial crisis. He later worked in Senator Barbara Boxer's office before finishing his career in the Maryland Legislature. The man knows the law. Georgetown ain't that bad of a school. After decades working at the highest levels of government, his assessment of Nevada Public Records Act was blunt. He said it was one of the most poorly written public records laws he had ever seen, with holes big enough to drive a truck through. His advice was simple. Don't even bother trying to get records because they were never going to release them. He told me to give up. Unfortunately, his defiant daughter ignored his advice, and as it turns out, he was probably right from the beginning. But now it's time to change that. It's time to look at the past and decide what needs to change for the future. I'm encouraged that so many people have embraced my proposal for an independent public records ombudsman. I hope we will also embrace the need for greater transparency when it comes to public officials. The elected, the appointed, and the exempt hold tremendous power. Because they wield that power, they should be held to the highest standards of integrity. And when they fall short, the public deserves to know. Complaints existed about people such as Tellis, Childress, and Cassidy. Earlier transparency could have exposed patterns, prompted action, and perhaps prevented further harm. Instead, the system remained as opaque as a sandstorm in the Nevada desert. Thank you.
Chair, the public line is open and working, and there are no other callers choosing to provide public comment at this time.
Okay, thank you. I'd like to adjourn the meeting at 2:51. Do I have to call a motion on that? Do I have a motion to
Leslie
adjourn?
Nino Puro. Move to adjourn.
Thank you, Leslie. Do I have a
Second.
second? And that's Brittany. Meeting's adjourned
Yes.
at 2:52. Thank you, everyone.
Bye.
Thank you.
Thank you, Kaylee.